Hey everybody, happy Friday. I hope everybody's doing well. Jumping into the chat today, I see a lot of people, lots of thoughts, right? This case is a big deal. So, I mean, there's like endless things that we could talk about for, death penalty, what life without parole would be like, what the family members might be dealing with, what the family members of the victims might be dealing with. So I do see all of your thoughts in the chat and hope everyone's having a good day and can do something that if this case is getting you in your thoughts, you can do something that gets your mind off of it and call the people you love, spend some time with the people you love. This is going to be day 5 of the penalty phase, and I think we're wrapping up with the closing arguments. So the state does not get a rebuttal close in the penalty phase. Unlike what we saw in the guilt phase where they can do an opening closing and then a rebuttal closing, they don't get that here. So what we heard from Scott Harmon yesterday was the state's final word, that the aggravating factors are here, and you, the jury, should recommend a sentence of death for these 4 defendants. For what we're going to see today, we're going to have the closing arguments from the 4 defense teams. So, again, I'm still not sure of the order, but of course we'll find out. I do have this morning, I am following the Antonio Brown case, and there's a hearing. So it's supposed to start at 9. They haven't really started off yet. So I'm going to probably be off screen for like 30 minutes, but I will be here and monitoring the chat to make sure our volume's good and listening in to the closing arguments. And then I'll be back with you guys for the rest of the day. We've got to get a poll up, you guys. We got to do a poll. So maybe for each defendant, we could do a poll. As each defendant goes, we'll put up a poll that's related to whoever's currently doing the closing arguments. And any other poll ideas you guys have, let me know. Yeah, Sheve's like, we've all been here together the last 5 days. Yeah, and I think it's been so good to see all of the different thoughts. I've seen some people change their thoughts. I've seen some people like have the same overall perspective, but like, oh, I didn't think of this other thing before. And as much as it's like a tough subject, I think it's a real serious learning experience to see something like this streamed. Again, I've read news about penalty phases. I've read a lot of appeals about penalty phases, but I've never been able to watch, like, we get a guilty verdict and then we have this whole presentation of aggravating and mitigating factors. I've just never watched a proceeding, like, with my eyes. So it's a first time for me to see this type of what we saw this week. Hey to everybody coming in. All right, and I'm going to let this one run. I will be here with you guys in the chat, but the judge is live for Antonio Brown, so I'm going to tune in on that one, you guys. Love you.
on his phone now, Judge.
Okay, great. Yeah. It starts off, see, we start off at Okay, very good. Welcome back, members of the jury. We are ready to proceed. And Ms. Finkelstein, on behalf of Sean Gathright, you may proceed.
Thank you. Good morning. Members of the jury, we have come a long way since you were selected a little bit over 3 weeks ago, and now we have reached the most demanding part of this trial. In just a little while, the fate of Sean Gathright is going to be out of our hands and into yours. If you remember back to jury selection, there was a lot of numbers, scales, questions posed to you over and over, and I told you at that time I wasn't going to hold you to those numbers. Some of us said we didn't really like the numbers. It was just kind of getting a feel for where you guys stand coming into a new scenario. And the reason I said that was because this isn't a test. This isn't a numbers game, not a math problem or an equation. This is most literally a life or death scenario. Soon you will have to decide whether a young 20-year-old man will spend the rest of his life in prison or whether he will be executed. Sean Gathright is not wicked. Sean Gathright is not evil. No matter how many times, no matter how many ways it could be said in the state's closing, he's not a mastermind. He's not a super coordinator or orchestrator. Apparently, he might even be a rocket scientist. The state can minimize or diminish the mitigation list that's in front of you. The state may think that something deserves weight or no weight. That doesn't matter. That decision lies with each and every one of you. The state's opinion or theory is just that. This part of the trial, as I told you in opening, is about the defendants, about Sean Gathright, and it's about each one of you. On several occasions, I heard Mr. Harmon when he was reading some of the mitigating factors that are on there, say, you can find that mitigating, that's fine. But lucky for you, you don't need permission. You can evaluate that mitigation exactly how you feel fit. Each and every one of them. This is your decision, a personal decision, and you never, under any circumstance, have to vote for death. In the state's close, Mr. Harmon presented a very strong case for why you should find Mr. Gathright guilty. You've already done that. That part's over. Went pretty hard on Mr. Gathright and painted him out as a person who led this whole thing. We wouldn't be here without him. That's his theory, and my theory is that's done to lessen the mitigation. That was done to convince you that what you saw and what you heard from this witness stand this last week from Mr. Gathwright's mouth himself shouldn't be given the significant weight that it deserves. But what it actually did was prove that a kid with no motive, no involvement, no history in that, can get wrapped up in a culture that he has no business in. The evidence was overwhelming that Mr. Gathwright's life has, and always will have value. Mr. Gathright is a human being worth saving, even in prison. People may think, well, you're in there for life or death, does it matter? You're in there. Yes, because you heard from Mr. Bonasco all the different ways that you can be useful, not only to the state from a financial perspective, if that matters, but to other people in prison, out of prison, his family that supports him no matter what, sits in here and listens every day. You heard what a positive, optimistic person he is from friends, family, guidance counselors. He can be a light in a dark place. Hopefully he can keep making people smile. Even now, from jail, you heard that he's still asking about other people when he talks to them, trying to keep them in good spirits while he's sitting in jail. While he is facing a death sentence, he's worried about other people. That's not wicked. That's not evil. The theme from those witnesses on Mr. Gathwright's behalf was he was positive, he was funny, he was witty, he made people feel good. You heard that he was kind and respectful and well-mannered. And you don't just have to take the word of family and friends that know him and of course want to come in and they want to save him, they want to help him. You saw it from Mr. Gathright. That young man had the courage to get up there and face you and talk to you and try the best he could to explain his remorse, his accountability, and his worth. And when he was questioned on cross-examination and tried to get riled up, he remained respectful. That's his character. That wasn't a show. He was authentic. He was real. He was honest. He didn't get riled up. He answered every question politely, with sir at the end, from someone who was cross-examining him pretty harshly, and who was seeking to have you vote to take his life away. He remained respectful because that's who he is inside. That doesn't change. Now, is that the reason that you should not give somebody a death penalty? Well, that's up to you. And that's why it's your choice. But what it is, along with the other testimony you heard, is that proof that good kids, good people, privileged kids, I guess we want to call them, educated, intelligent, worldly, that those types of kids, Sean Gathright was not isolated or insulated or immune from getting wrapped up in something that he had no business in. He's an 18-year-old kid who is not immune from outside influence, curiosity. He told you himself, yes, I had a privileged life. I had people that loved me. I got to travel. I saw things. I did things. I had opportunity. And I still, after leaving that bubble, saw parts of Jacksonville, parts of a culture that I didn't know were out there. And look where he finds himself. That curiosity from that 18-year-old kid brought him right here. You know, the state said, oh, Mr. Bonosco, who testified, the prison expert, said Mr. Gathright was mature. I think everybody did. I think you can see it for yourself. He's mature. He appeared mature for his age. Well, Mr. Bonosco is basing that on a conversation at the jail for, I think it was a little over an hour. But either way, because he worked, traveled, helped support himself, cared for others, went to school, presented himself as grown, can take care of himself, that might be mature for an 18-year-old. But he's still 18. Maturity on the outside is not the same thing as being a developed adult and having life experiences, having knowledge, having street smarts. It's not the same thing. You can be well-spoken and smart and mature and still make really bad decisions. He is impressionable. He's naive. He was curious. He told you he was easily influenced. That matters. He told you himself that he was more vulnerable to influence and more likely to follow others, probably based on his lack of seeing other aspects of the culture, other aspects of Jacksonville. And we heard that it's pretty rough there. Because he was 18, he was less capable of kind of stopping and saying, wait, maybe this isn't taking me where I need to go, and seeing the end result. He doesn't have that experience or that knowledge. He told you that while he had male influences and guidance in his life, at the times that he felt it really mattered, when Brian Harrington, his stepfather, who was a great guy, divorced his mother 2020, Sean Gathright was only 15. So from 15 till he lands in jail at 18, he didn't have a steady, constant influence in his life when he needed it the most. He's not saying he didn't have anybody. He's not saying all the people that come here to support him and love him weren't really there. They were. But he's a kid. He's feeling his way through things. And it wasn't constant, and it wasn't there for him at those years. And that fact doesn't excuse any conduct. It doesn't remove accountability, but it explains how a young person with so much promise can make a catastrophic decision that could define the rest of his life. That one decision. And I told you in opening that mitigation isn't an excuse. I'm not up here to make excuses for Sean Gathright, and he wasn't making excuses for himself. He wasn't blaming anybody. It's an explanation, and it's a reason. And that's what mitigation is all about. It helps to understand what I'm sure everyone is wondering is how he got here. It's his story. He took accountability. He showed remorse. Remorse is defined as deep and painful and often long-lasting feelings of guilt, sadness or regret for past wrongdoing. Not at the moment. Most people don't feel remorse while they're doing something wrong. They feel it afterwards, and that's what you saw. That wasn't contrived. That wasn't fake. That wasn't for your benefit. took a lot for him to get up there, and he wanted to. Accountability is obligation or the willingness, which you saw, to accept responsibility and account for one's actions, and that's exactly what he did. He was straightforward, he was composed, he was wholly authentic. And he told you, what led him there, what his curiosity did to him. And you had heard from Maurice Edwards, the state tried to say, one of the mitigators was about, him, his instability or not being able to adapt, and Maurice Edwards did tell you that at a younger age, being that he had some experiences and that Sean traveled and was not as steady in a place, he has a biracial family, that he did feel some sense of instability. Where do I belong? Where do I fit in? And of course you're going to. You're traveling all over. Yes, you're seeing great things, but he's still a kid. And he admits, Mr. Gathright told you, step foot in the jail and immediately thought, where did my path veer? And instead of feeling sorry for himself, getting down on himself for this situation that he and nobody else that you heard from saw coming, he cracked his Bible. He told you he talked to God. And he's trying to make the best of a situation that he finds himself in. He said something that I felt was pretty profound, that he said, people are always asking God for something, praying to God to give them something or do something for them. And he thought, I can ask God what he wants from me. So even in this situation, he can be a light. He can help people. He can try and turn lives around for kids that he comes into contact with, or adults. In a dark, dark place, he sees hope. He sees a future. And I'm up here asking you to see that future for him. See the hope in him. See the redemption in him. A lot of the questions of our mitigation witnesses and then some of the state's closing was thinking, oh, he's a privileged kid, he had it all. Does that mean he's not worth saving? I would submit to you that it's the absolute opposite. There's a long list of mitigating factors that you'll have in your instructions, and the state went over a lot of them. I think there's 32 for Mr. Gathright. I'm not going to read them all to you right now. But you'll have them when you deliberate. And it's a long list for a reason. It's a long list because in his short 20 years, 18 when this happened, he really made an impression on this world. So it's a long list. Imagine what he could have done if he had more than 18 years. And remember, that's just a list that we're providing you. Mitigation can be absolutely anything that you want. Anything you heard in the first phase, anything you heard in this phase, or just because you don't think that this young man deserves to die. The law says that you can find those aggravators that the state proved to you in the first phase, reminded you of yesterday. You can find that those were proven. You can find that they outweigh the mitigators, and you never have to sentence someone to death. The death penalty in this phase is not whether to punish, but how. It's not about whether Mr. Gathright will die in prison, but about when and by what means. Natural causes are at the hands of the government. The death penalty is not appropriate in this case. Mr. Gathright does not deserve the death penalty. This is the only time you have to make this decision. You can't change it tomorrow. You can't change it next week. This is it. A vote for life does not excuse any criminal behavior. It's not an excuse. It doesn't excuse responsibility for a crime. A vote for life doesn't diminish the life of Charles Jones or the loss to his family or his loved ones. A vote for life in this case is the just decision. It's the right decision for Mr. Gathright. Do not define Sean Gathright by the worst decision, the worst moment of his life. Sean Gathright is a son who's worth saving. He's a friend worth saving. He's a nephew worth saving. He's a grandson that's worth saving. He's a baby brother worth saving. He's an uncle worth saving. I'm asking you to do just that. Thank you.
All right, thank you. Mr. Petredis, on behalf of Isaiah Chance.
Please, the court. I want to thank you again. You're going to get a lot of thank yous today, and they're well deserved. We are at the end of your service, but as I said in my opening, we are also probably at the most difficult part of your service, and we all understand that. I want to start by saying justice will be served. Isaiah Chance will spend the rest of his life in prison, punished away from society. All we are asking is that you spare his life. Death is never required. The death penalty exists for the worst of the worst. We submit that Isaiah Chance is not that. As I said, he will pay for this crime every day for the rest of his life. We are asking you to let him have that life. This is going to be a conversation about life, a request on behalf of a young man and his family, Isaiah Chance, someone from Jacksonville, lived with his mother, who sat in his grandmother's lap, who called his father all the time, went to Atlanta to be with his grandparents. A man with 3 children. That's who you are deciding about today. A man who spent every day of his life working harder than those around him, just trying to keep up and working harder to make it seem like he wasn't doing that. You heard from 6 people and a doctor, 6 people who love him and a doctor from that chair, and they told you who he is. They're asking for you to believe them and to listen to them. The law gives you this phase of the trial for a reason. You have decided guilt. We are past that. It asks you to decide who Isaiah Chance is and who he is and how he got to be that if he's worth saving. As Ms. Finkelstein said, mitigation does not excuse. Mitigation explains. I'm asking you to look at Isaiah Chance, the full human being, and decide whether death is appropriate, if death is the answer. And death, we would argue, is never necessary. You heard from his entire family during the penalty phase, and like I said, a doctor. 7 different witnesses from 7 somewhat different vantage points, but all told you essentially the same thing. From Victoria Gray, she described his mother. She described him as quiet, gentle, close with his family, never violent. Someone who really didn't want to play football, who had goals, who wanted to be a merchant seaman, an entrepreneur, who was trying to build something. She told you him and his entire family had hobbies, I think she said martial arts, that they would do together because they loved each other and they genuinely wanted and loved to be around each other. Think about her, what it takes to raise 6 children, not on her own, but in large part on her own, in Jacksonville, and each one of them know that they are loved. Isaiah Chance clearly knew he was loved by his mother. He told you that himself through his interviews with the doctors, told you that by how he acted with his father, how he acted with his grandparents, how he acted with his children. He got that from his mother. She gave that to him. It didn't come from nowhere. You heard from Isaiah Chance Sr., a United States Marine, who after serving came back to Jacksonville, who after getting divorced from his mother, stayed in his child's life, stayed in Isaiah Chance's life. When he would help him with his schoolwork, he saw him struggling. And he said, hey, that reminded him of himself. You're like me. I struggled. Keep going. I see you. Not an excuse, but just, I see you work. I see you working. He told you something else. He said that Isaiah called him all the time. And every time he hung up the phone, he said the same thing beforehand. He said, I love you, to his dad. Every single time. Something so ingrained, it was subconscious or subconscious, but he said it. No one's listening when you're talking to your father on the phone. It's not performative. It's just something you do. And he decided at some point, like I said, maybe subconsciously, that every time he talked to his dad, he wanted to let his dad know that he loved him. That is not something, again, that he decided to do performatively. That just shows you that's him as a son. Heard from his grandmother, Elizabeth Jordan, Nana, I think she said. She said he used to sit in her lap when he was a baby, and if he could, he would do it today. She told you that her and Papa used to take the grandchildren on vacation and take them to church. They were there for the grandchildren, and when they needed Isaiah, he was there for them. She told you when Papa was sick, he was, I believe, 7 days he was in a coma. Isaiah Chance didn't call and see how he was doing. He didn't text and see how he was doing. He showed up. He stayed at the hospital until he woke up. And then when they needed someone, when Papa wanted to go home to be with his wife in Atlanta, she couldn't care for him on his own. They called Isaiah Chance, and he showed up time after time. I think it's, like a 5-hour drive from Jacksonville to Atlanta? And he made it over and over again for years to be with his grandparents, to help take his 260-pound grandfather out of bed when his grandmother couldn't, when he was 19, 20, and 21. When most kids are thinking only about themselves, Isaiah Chance realized that when family calls, you show up, and he did that. I think that's an important part of Isaiah Chance and who he is, someone with value. And I ask you to remember that as you deliberate. You heard from Michelle Smith, his godmother. Knew him, she said, before he was born. Had a good relationship with him, and she said she would always tell him the truth. That's AC kicking on, thankfully. She supported.
I'm sorry to interrupt you. It sounds like the AC has kicked on, and so Mr. Petredis, just if you can try and just do this now. It sounds like a windstorm over there. So.
It's a good thing, though.
Yes, it is a good thing.
And you heard from Nashawn Nix, his former stepfather, his mentor. And he was someone I thought was a very important witness. He's not blood related to Isaiah Chance or his mother, obviously. Didn't have to be here. He was in Isaiah's life from 7 to 12, so a little while ago. And he built an organization whose entire purpose was identifying young men who can be reached and investing in them. And he saw many that couldn't be reached. And he showed up here. He told you when he was with Isaiah, he noticed things. He would go to school meetings. He would talk to him after school. He would talk to his guidance counselor. He noticed things the family saw as well. He was pushing for tutoring, for structure, and for support. And years later, after he was out of Isaiah's life, no longer with his mother, Isaiah Chance needed a letter of recommendation to be a merchant seaman. And he went to Mr. Nix. And Mr. Nix saw something in Isaiah Chance, and he put his reputation on the line, and he wrote that letter of recommendation for him. That's not obligation. That is not sentiment. It's a man who spent his career learning to see who people are, and he saw something in Isaiah Chance, and we're asking that you see the same thing. You heard from Miss Wade. She's known him from about when he was 16 years old to when he was becoming an adult. She said when she needed someone to house sit, when she needed someone to pet sit, and anyone who knows pets knows that that's a serious obligation, someone to let someone else watch their pet, she called Isaiah Chance. She never had any issues. She never had any trust issues. He did it every time. That's not someone you let do that unless you genuinely trust that nothing will happen. And she told you he would talk to her about his plans for life, specific plans, his goals, what he wanted to accomplish. And she plans to stay in touch with him while he's in prison. Tells you everything about what kind of person inspires that kind of loyalty. 6 witnesses, 6 different relationships, telling you 6 different years of Isaiah Chance's life, different eras, all telling you the same thing. He was quiet, respectful, gentle, loving, nonviolent. a young man who needed a little more structure than the world gives to most people. Then there's the science. Dr. Tracy Hardig, forensic psychologist. She spent hours with Isaiah Chance. She did actual IQ and academic testing. She reviewed school records going back to when he was in preschool. But before that, let's talk about what she said when she noticed him. He was quiet, he was mild-mannered, he wanted to be there. He wanted to do the test. He was not depressed. And he kept saying the same thing essentially throughout the testing. I'm smart. I know I didn't do great in school, but he wanted to impress her.
Look at Scott's
And
face.
he used some big words, and I would say he used some correctly and some incorrectly, like he did with Dr. Warner. He got a full-scale IQ of 71. That's what she got through the testing. At age 22, he reads at a 5th grade level. His math is at a 3rd grade level. The things that a lot of us take for granted in life that we get through life are genuinely harder for Isaiah Chance. Not impossible, just harder. She reviewed his Duval County school records, which I believe Dr. Warner glossed over. He had 3 tests done in his school, and they all said the same thing at ages 4, at ages 10, and ages 12. 3 different other evaluators, independent. At age 4, said he had issues with speaking, and we heard from multiple of his witnesses telling you that he was nonverbal at that time. So corroboration. At age 10, he got the same score as Dr. Hardig got, corroboration. And at age 12, he was even a little bit lower, again. And then he's removed from that school. People with IQs in this range are not unintelligent. They can form relationships, they can have jobs. We're not asking you to weigh his IQ as an excuse, but just as context, something you can weigh when you're back there deliberating on mitigation. She also diagnosed ADHD, and the clinical observations you saw from school showed the same thing. Off task over 30% of the time, way more than his classmates, and it was never treated. The state talked about a co-defendant not having IQ tests because they didn't provide corroboration, and they talked about that as a bad thing. Well, we have corroboration from 3 IQ tests, and they don't want you to look at that, and I'm asking you to look at those IQ tests that corroborate Dr. Hardig's and go against what Dr. Warner said. And the last thing I want to say about Dr. Warner is she said that she trusted the testing that was done in school, trusted the testing that Dr. Hardig did, trusted and agreed with the results of both, but disagreed with the diagnosis, which is based on the results. I would say that doesn't follow. We also heard that he could be vulnerable in the wrong environment. He has a lifelong need to belong, and that's a human, that's a character. It's not a character flaw. It's just a human need. But I want to talk about what the right environment looked like. That looked like what Mr. Nix provided. When Mr. Nix was there, when he provided structure, when someone was paying attention, made real progress. Isaiah made real progress. It tells you something. Isaiah Chance is not someone who's beyond reach. He's someone who does better when someone is paying attention. We're not here to ask you to believe that he will never struggle again. We're asking you to believe that struggle will be worth it, that he has value, that it matters, that he is not what happened in the worst moments of his life. Now, the state pointed to the aggravators. They spent a lot of time on the aggravators, and we're not here to minimize what happened, not at all. We're not here to argue those either. We're here to talk about this young man, him as a human being, about things that make his life worth saving. We're here to tell you we believe the mitigators outweigh the aggravators. Like Ms. Finkelstein said, you're going to get a list of the mitigators. I'm not going to go through all of them. I do want to go through a few of them. And you give whatever weight you believe to these mitigators. Isaiah Chance has no significant history of prior criminal activity. You heard from his mom and his dad, no arrests, nothing. His age at the time of the crime, he was 21 years old at the time of this crime. He was a young man. Like I said, he suffers from borderline intellectual disability and untreated ADHD. His loving relationship with his children, which I'll get into in a little bit. His loving relationship that you heard from his family and friends that goes both ways. Isaiah Chance did not carry, use, or threaten to use a firearm during the commission of this offense. Let me be clear, this in no way lessens his guilt. But it is a fact that you can consider when you're back there, that he did not have a firearm during this offense. And again, there's the catch-all. Anything else you heard from any witnesses on that stand that you saw, that you believe is a mitigator, you can use. Isaiah Chance is a son, a brother, a grandson, and father whose life has meaning to others. His children, Kabri, Kylan, and Amiri. His mom told you he was a great father who wanted to be involved with his kids. Miss Wade told you he was always calling her, asking her for advice. He wanted to be involved. He was present. He was trying to be a good father. He was 21 years old with 3 kids, actively seeking out guidance to be a better father. That is not the behavior of someone who doesn't care. That is the behavior of a young man who understood that fatherhood mattered and was trying imperfectly to rise to it. He cherishes fatherhood and has a great relationship with his 3 children. That is not nothing. For a 21-year-old who may have some limitations, trying to figure out how to be present for 3 children, that effort means something. It tells you something about who he is when the stakes are personal. He showed up for his children, just like he showed up for his grandparents. It's not a legal argument. It's a fact about what it means to be human. His kids are growing up right now. One day they will be old enough to know their father, to write him a letter, to ask him a question only he can answer. And he will be in prison. But a father can still be a father behind bars. A letter, a phone call, a presence. We are simply asking for you to leave that door open. 7 people testified in the penalty phase. 6 who have known him parts or all of his life, and a doctor. Dr. Hardy told you the clinical side. People like Isaiah are a little more vulnerable. They want to belong. They want to follow because it's safer than the alternative. He spent his entire life working harder than other people, failing and trying again. He put his family first and truly sacrificed on multiple occasions when it mattered. He sat in church with Nana and Mr. Nix and talked about God and life. He was a great brother and a great and attentive father. He was someone's son, someone's grandson, someone's father. He's a human being with limitations and with love. You heard about the continued support he will get while in prison. On behalf of his mother, who raised him with structure and love, his father, who was there for his son and still wants to be there for his son, Elizabeth Jordan, who he sat in her lap his entire life, Nashawn Nix, a man who owes him nothing but showed up here to tell you that he loves him, and he better know that he still loves him. We are asking you to spare his life. The family did not need to come here. They chose to. They sat in the witness chair knowing everything that you know, and they want to tell you that this person is not beyond saving. They're not in denial. They know what happened. They still came here and they're still asking. That says something about Isaiah Chance that no test score or school record can fully capture. It tells you the people who know him best, who have seen every version of him, have decided he's worth fighting for. And we are asking you to agree with them. The death penalty is reserved for the worst of the worst. And we would argue that Isaiah Chance and the facts of this case do not meet that criteria. He's not the kind of person for whom there's no threat of redemption or no evident conscience that the death penalty was designed for. Death is never required. Again, as I say in my opening, the law favors life because it always gives you the opportunity to give mercy. We are asking you to consider that a person can do something unforgivable and still not be beyond the reach of mercy. Isaiah Chance will spend the rest of his life in prison. He will carry what happened to him every day. We are not asking for you to forgive what happened. We are not asking you to forget it, minimize it, or look away. We are asking you to look at the full human being, everything I've talked about and everything you've heard from the stand, and decide that death is not the answer. Justice will be served. He will spend his life in prison. Today's the last day he's going to wear street clothes. Last time we'll put a suit on. Mercy does not mean forgetting. Mercy means choosing deliberately and with full knowledge what you know to let someone live. The law gives you that option, gives you the option for a reason. We are asking that you use it. We are asking that you spare Isaiah Chance's life. Thank you.
Okay, very good. Ms. Toumey, on behalf of Davion Murphy.
All right, finishing up the Sean Gathright poll, so get your votes in on Sean and we'll do an Isaiah Chance poll.
Davion Murphy was born January 10th, 1997. a blank canvas, wide-eyed to the world, not knowing his limitations, not knowing good from bad. But children learn what they see every day. When children learn criticism, they learn to condemn. When they learn hostility and violence, they become violent and fight. When children live with instability, they become unstable. Now, as I told you in my opening, Florida has no parole, there's no gain time. As Davion Murphy sits there now, and all of these other defendants, they will be given life in prison. The only question for you is when he dies, either by natural causes or by execution. That's the only decision that is left to make. And this is probably the most important decision that you will make in your life. The fate of another human being is in your hands. I want to pose a question to you, and that is, what good comes from executing Davion Murphy? It seems like a simple question. It's not so simple. I think it was Gandhi that said, an eye for an eye eventually leaves everyone blind. There is no need to execute Davion Murphy. Life in prison, a life, along with thinking about this every single day. Perhaps even maybe walking down the same hallway as his father, stomping the same concrete in those hallways in the Florida Department of Corrections as his father, his uncle, his younger brother that testified, his blood cousin, Rashad Murphy. A vote of death will only be the next statistic in this gang war that started in Jacksonville. It'll be just another statistic. And what comes from executing another human being? Nothing comes from it. It's not going to bring Charles Jones back. It's not going to change the events that occurred on June 23rd of 2023. It simply perpetuates the violence that started long, long ago, not here in Hillsborough County, but in Jacksonville. As you heard from the state's witnesses, the detectives, the gang detectives, so much violence so in these gangs that they have detectives that are given certain gangs to follow. That's what Davion Murphy grew up in. He grew up in East Jacksonville. Davion Murphy wasn't born into a life of privilege and opportunity. He was born into violence and instability. What chance did he have? And folks, I'm not offering you an excuse for these events or what happened. It's tragic. I'm simply offering you context of the facts. Context. Davion Murphy was 12 years old when his father, who suffered from schizophrenia, was given life in prison for murder, along with his uncle, his parental uncle, who also was given 50 years in prison for murder. When he was 12 years old, his father was gone, absent from his life. And you heard from his youngest brother, Adam Gooden, his youngest brother, who broke down in front of you all. Well, they grew up in the same environment. They had the same mother. They had different fathers. But if you recall, Adam Gooden also told you that his father was incarcerated in prison. This is a generational violence, instability, insecurity that these men grew up in. When I say these men, I mean Davion and his cousin. And you got to see this firsthand through the state's witnesses, their detectives, as well as through the individuals that testified on Davion's behalf. Take a technically, intellectually disabled child with learning disabilities, throw him into the violence and crime in the streets of Jacksonville. What happens? They look for comfort. They look for a father figure. What becomes the father figure for them? The streets, the gangs. Now, as you saw, not only did Dr. Eisenstein, and we'll get to that in a moment, but Dr. Eisenstein testified that he was borderline intellectually disabled. They had long ago indicated that Davion Murphy had a mental disability. He was in special classes, he was in IEP classes, he had to repeat various grades, and he also suffered traumatic brain injury from all the various events that occurred in his life. Multiple motor vehicle accidents, fights, falling off a golf cart, or running a golf cart into a tree. And folks, these scans, these images weren't done because he was found guilty. The state knows better than that.
Judge, objection, that's an improper statement. It's a misstatement of the law, and that's improper.
I'm going to sustain the objection.
These scans were
They
done
hate each other.
to show you that Davion Murphy suffers brain damage. What does Dr. Rubino have to come in here to risk his medical license to say, and you saw the scans, and you could take it back if you want to look at them, to say that he suffers from brain damage? And the state had its radiologist, a diagnostic radiologist, of whom I respect, Dr. Glickstein, I respect, but he doesn't have the knowledge and the upkeep of the new technologies. He wasn't able to, he hasn't seen he said, I think it was like once an MRI, DTI, which is commonly done in these radiology facilities. Why would a neuropsychologist recommend scans that a neurologist send to a radiology facility that then conducts the scans and gets those images, perform those? It's a big liability there. I suggest to you that he does have brain damage. You can watch the interrogation video yourself. That's demonstrative evidence of the state of mind of Davion Murphy and his intellect. Now let's talk about a little bit about mitigation. As you've heard, it's not a numbers game. It's not a calculation. It's not who's got more mitigation. It's about the weight and the significance of that mitigation. I'm not going to address the aggravating factors. I'm not going to waste your time. I'm not going to insult any one of you. But the mitigation that was presented on behalf of Davion Murphy is substantial and is great, and it deserves great weight. And you also have to remember that the mitigating circumstances have to be proven, not beyond a reasonable doubt, but by a preponderance of the evidence. I submit to you that Dr. Eisenstein, who met with Davion Murphy 7 times in person over the course of 6 months for over 20 hours, has a better idea, a better understanding of what Davion Murphy is about, not Dr. Warner, who met with him by Zoom for 80 minutes. And then when asked by the state about why she had such limited time, was because the jail only gave her 3 hours or something like that. Well, if you only had 3 hours, then say you need enough time. You didn't have enough time. You can't render a proper diagnosis.
I
render
agree.
an opinion because you didn't have enough time. Dr. Eisenstein had enough time. He took the time to know Davion Murphy, went through his records, his medical records. And why did we not provide Dr. Eisenstein with police reports, videotape interrogation, videos and such? Because we wanted to make sure that there was no bias, that Dr. Eisenstein met with Davion Murphy, without any bias in his mind. That's why. I suggest to you that Davion Murphy's life is worthy. Davion Murphy is worthy. That he is redeemable. That he's made a grievous mistake. And that he should be punished. He will be punished. He's being punished every day. And he will be punished every day for the rest of his life. There's no doubt. But it's your job to look at him as an individual, all of these defendants as individuals, and not compare one to the other, but look at each of them as an individual person, and then decide whether the mitigation, which has a lower burden, and rightfully so, has been proven and substantially or outweighs the aggravation in this case. It has to make the crime more grievous. It doesn't. Life is the appropriate sentence. There's nothing that a death sentence is going to do in this case. So the mitigators that you have on behalf of Davion Murphy is the capacity of Davion Murphy to appreciate the criminality of his conduct or conform his conduct to the requirements of law. That's one. He's got 13, but once again, it doesn't matter. It doesn't matter if you've got 50 or if you've got 100 and it's not a numbers game. It's not who's got more or who's got more aggravators versus mitigators. The second one, the capital felony was committed while Davion Murphy was under the influence of extreme mental and emotional disturbance. That's where Dr. Eisenstein comes in. That's where Dr. Rubino comes in with their testimony. the age of Davion Murphy. He was 27, but when you consider the testimony of Dr. Eisenstein, the age of the person on the outside isn't necessarily the age of the person on the inside. Davion Murphy suffers from traumatic brain injury. Yes, Dr. Rubino testified that he did. And doctors, they disagree. They do disagree. You have to decide who you believe. And once again, we don't have to prove beyond a reasonable doubt that these mitigators exist. Just a preponderance of the evidence, greater weight of the evidence. Davion Murphy is in the borderline range of intellectual disability. Let's talk about Dr. Warner for a minute. She indicated that he was low average, I think is what she testified to. But she's not, doesn't have the ability to do any psychological testing, didn't do an IQ test, didn't do really basically anything. She did a mental status examination of Davion Murphy. That was not rebutted, wasn't disproved. Davion Murphy did not have a stable role model in his life. No, he did not. Neither did his younger brother. Davion Murphy's father was diagnosed with schizophrenia. Yes, you heard from Winston Murphy, who was very reluctant to testify, but yes, that was his brother, and he testified that his brother, who was Davion Murphy's father, was diagnosed with schizophrenia. Davion Murphy's father was incarcerated for life when Davion Murphy was 12 years old. Yes. Davion Murphy took on a parental role for his younger siblings. Yes, because he had to. Adam Gooden testified that he had to sell, or they would sell a PlayStation or something like that to get food. Davion Murphy is loved by his family. Yes, yes he is. And then the existence of anything else. That means that mitigation to you can be anything else that you decide it to be. You get to decide. Maybe it's something I didn't say or wasn't presented to you. Maybe it's something that just because you think life is more appropriate than death, than execution. Because this vote is individual to each one of you. It's an individual moral judgment that each one of you have. Yes, you have to go back and discuss the evidence and things, but it's your vote. It's not anyone's vote, and don't let anyone else try and convince you of what your vote should be when you go back there. It's your decision. Folks, gang violence tears apart families, neighborhoods, and futures. And that's exactly what it did with all these families, Charles Jones' family. The death penalty only guarantees that suffering and that violence continues. Life in prison for Davion is a just punishment. It removes him from society. And we can be tough on crime without the death penalty and just giving him life in prison. Now, this is the verdict form. And once again, just like in the guilt phase, excuse me, just like in the guilt phase, just because you didn't hear from Davion Murphy, like you heard from Sean Gathright in the penalty phase, doesn't mean you can hold that against him. He's got the right to remain silent, and you cannot use that against him. Just want to remind you of that. Or any of the defendants that did not testify in the penalty phase. But here's the verdict form. 3 pages long, but on that second page is where it has jury recommendation. And you might think, well, it's just a recommendation. It is, but your recommendation will be given great weight by the court. So when you vote, it's going to be the vote. It's going to be the deciding factor as to what these individuals get, life or death. If fewer than 8 jurors vote for the death penalty, your recommendation must be for the penalty of life in prison without the possibility of parole. Fewer than 8. That means 7 of you can vote for death, 5 of you can vote for life, and they would get life. I submit to you that you really don't need to even get there, folks, because you could just go right to the bottom and find that Davion Murphy should be sentenced to life in prison without the possibility of parole. That is a just punishment in this case. This is not the most aggravated of murders and the least mitigated. What good would it do to execute an intellectually challenged, brain damaged 29-year-old male who's grown up on the streets of Jacksonville just trying to survive the gangs and the violence? He lived and did what he saw every single day. He's going to be punished enough. You can tell Davion Murphy that he did a terrible thing. This is terrible. It's tragic. But you can also tell him that he's redeemable and he has worth with a vote for life. Thank you.
Thank you, Ms. Toomey and Mr. Hernandez, on behalf of Rashad Murphy.
Please, the court.
Yes.
Counsel. Good morning, ladies and gentlemen. I want to begin again by thanking you very much for your service, your attentive service in this case. As you know, I am speaking on behalf of Rashad Murphy. I cannot imagine an attorney having a more overwhelming responsibility than advocating for a man's life. And here we are. As we go through the evidence that was presented and the mitigating circumstances that have been proposed, I want to make sure that there is no attempt to misstate. If I say something, I've got notes, you have your notes. If I say something that you remember differently, please rely on your notes and your collective memories. You've heard it several times during this case, and I'll go briefly through it. Your recommendation is extremely important. It carries great weight. The judge has to give it great weight. And the mitigating circumstances that have been proposed by Rashad Murphy and the other defendants only have to be proven by the greater weight of the evidence. If you believe that it more than likely exists, you can consider it and give it the weight that you decide it deserves. And those mitigating circumstances can be facts about the case, or it can be facts related to Rashad Murphy as a person, as a human being, such as the mental issues that have been presented, his childhood, his history, his accomplishments. It can also be your personal observations of Mr. Murphy's behavior during the last 6 weeks, as you've had a chance to observe him for 6 consecutive weeks. And your vote, although you deliberate, each vote is individual. And although there is a weighing process, you ultimately are being asked to decide what is the appropriate vote, either a life recommendation without the possibility of parole or death. Ladies and gentlemen, nothing that I am saying during my closing arguments is designed to in any way minimize the tragedy for Charles Jones and his family. Death resulted regardless of the details. His family, the family of Mr. Jones, grieves regardless of the details. All that is a given before your analysis in this penalty phase begins. And the same principle applies to the crime of murder. All murders involve some level of violence, some less, some more, but they all involve some level of violence. All first-degree murders involve either premeditation or while committing a serious crime such as robbery or rape. Nevertheless, and that's why we're here, nevertheless, not all first-degree murders warrant the death penalty. And I submit to you that in the case of Rashad Murphy, the death penalty is not warranted. But we need an analysis of the facts of the case, but also of the person who Rashad Murphy is. You heard from several family members. You heard from his fiancée, Charmaine Staker, and the mother, his fiancée, that they've known each other for, I believe, 15 or more years, and the mother of his 4 children. You also heard from 2 of his aunts, Hazel Dickerson and Jamila Murphy, as well as his uncle who's in prison, who testified here as well, Winston Murphy. They all made it clear to you that they love him very much and that he has a lot of redeeming qualities. They all confirmed, in one way or the other, they all confirmed Mr. Murphy's difficult childhood, his personal history, being an excellent father and brother to his siblings. They all had some knowledge, some more, some less, of the physical and emotional abuse that Rashad Murphy suffered growing up, that he witnessed gun violence and lived in a high crime area, that he was raising 6 children when he was arrested in this case, his 4 children and 2 of his younger siblings. And despite working and having a limited income, he was raising 6 children. You heard that he was consistently employed, and that you also heard from Ms. Steger, his aunts, that they would continue to have contact with Mr. Murphy and visit him in prison as he would be serving if he ultimately gets a life sentence without the possibility of parole. And with something that Mr. Harmon said yesterday, I want to make it clear, and I think you would agree. The fact that he has some loving family members, such as his fiancée, but going back to his childhood, having 2 loving aunts, does not in any way erase the extremely difficult childhood that he had without a father and with a mother with a serious drug problem. And obviously he was taken out of the family home and placed into foster care because of that. You also heard from Dr. Collins, a licensed psychologist. He testified and has previously testified as an expert in neuropsychology. He was appointed by the court and paid by the state of Florida. He was asked by me to evaluate the defendant, Mr. Murphy, and possibly testify in this case, which he did, obviously. Before he testified, he was provided reports, not everything in the case, but provided records to review. Some about the case itself so that he would have a sufficient amount to become familiar with the facts of the case and the evidence in the case. But also about the defendant, before he even sees the defendant at the jail, things that would give him knowledge of the defendant as a person, his background, his childhood history, his mental history, jail records, because by that time he's been in jail on this case for a period of time. And then he has contact with the defendant on 2 occasions. I believe his testimony that he ultimately spent a total of 7 hours with Mr. Murphy. Part of that contact is to interview him, just chit-chat, have a conversation with him. And the purpose of that is to get to know him, to find out, to determine whether he is going to be cooperative and whether he is going to provide truthful information, because whatever he says can be compared to records that he's had a chance to review. And then part of that time is to conduct psychological testing, standard accepted test to analyze and diagnose. Dr. Collins testified, and none of this really is being refuted by the state. He was cooperative. There were tests done to find out if he was in any way faking and malingering. That was not the case. He was definitely cooperative and not malingering. The important thing, or at least one of the important things, is that the interview, the testing, and the records that were reviewed by Dr. Collins were all consistent, clearly indicating that Mr. Murphy was being truthful regarding his self-reporting about his childhood, about his background, about his history, and about his mental state. Dr. Collins testified that Rashad Murphy suffers from anxiety and depression stemming from childhood trauma that would be intensified throughout his adulthood. That Rashad Murphy, was physically and emotionally abused by his father, by his stepfather, and in the foster home. And that his mother suffered from severe drug addiction and ultimately died, where leaving Mr. Murphy with having to, by this time he's of course out of the foster home, and having to take care of his younger siblings. He confirmed, Dr. Collins confirmed, that drugs and violence were common in his community, in the community that Rashad Murphy grew up in when he was not in foster home. Ladies and gentlemen, I'm trying not to be repetitious, but the fact is that Rashad Murphy was born into violence and suffered a lot of abuse and neglect. He was removed from his father's care by the state when he was a small child. And all of this is confirmed by Dr. Collins, not just talking to Rashad Murphy, but looking at all the records. And then, as I said a minute ago, is that back after, I think it was 2018, when his mother died, he adopted his younger siblings. He was employed, but obviously a limited income, trying to not only financially support his fiancee, his 4 children, but also his 2 younger siblings. Dr. Collins also confirmed other records, and of course you heard from Ms. Steger, that he had a loving relationship with his childhood sweetheart and mother of his 4 children, that he was an excellent father, hard worker throughout his adulthood. The diagnosis by Dr. Collins is that Mr. Murphy suffers from post-traumatic stress disorder, PTSD. And as you know, it's a mental condition triggered by experiencing and or witnessing terrifying events. And it disrupts daily life. It affects his judgment, his decision-making as an adult. And it goes back to his childhood. Once someone has PTSD, it doesn't magically go away. It can be treated with psychotherapy and medication, but his condition is always there and does not go away, and it relates back to his childhood. And again, I should point out that, and I'll get to it in a minute, that Mr. Harmon, in cross-examination, I think, tried to discount it somewhat, but there was never anything presented by the state refuting this diagnosis. There was also the fact that his father, Rashad's father, had mental problems. That was documented. And also that Mr. Murphy's condition was noted in the jail records by state doctors before Dr. Collins even got involved. So you have corroboration that is and not disputed by the state, discounted, but not disputed. There's no expert saying otherwise. You also, through the testimony of Dr. Collins, you heard that several examples of Mr. Rashad Murphy trying to help himself, better himself as a person while in prison. Ladies and gentlemen, that evidence has more than one indication. I suggest to you that it does show that he's trying to better himself as a person, but it also shows that it's indicative of him not being a troublemaker, adapting to prison life, following strict rules and regulations, that if he was sentenced to life in prison without the possibility of parole, he would not be a problem, a troublemaker in prison. He's been in jail 2 years without any problems. And as I said, trying to better himself, you have the exhibits that you can look at when you go back to deliberate. There were 3 composite exhibits presented to you. One is Defense Exhibit 1 dealt with education. He got his GED while in prison, while in jail, not prison. He got his GED while incarcerated on this case. He also, there's a series. Defense Exhibit number 2 has several, I forget how many, 8 or 9 attached to that exhibit about different religious certificates and classes that he's attended, different religions, just showing religious awareness. But it also was presented during the testimony that he not only has been taking these classes, he has been teaching some of these classes to other inmates. He serves as a mentor in prison, in jail. I keep saying, I don't mean to say prison, Hillsborough County Jail. And then Defense Exhibit number 3 is a composite of certificates dealing generally with self-help, parenting classes, dealing with Alcoholics Anonymous, emotional regulation, things of that nature. And ladies and gentlemen, think what I'm saying, it feels it's too obvious to mention. None of this testimony and exhibits are offered as legal defenses or excuses for the homicide. But as you know, all first-degree murders are inexcusable. But they certainly are offered as valid mitigating circumstances, showing that the defendant, Rashad Murphy, has many redeeming values, showing that a life recommendation is appropriate. The court, when we get to part of the instructions, when we get to specifically Rashad Murphy, the defense is offered to you a series of proposed mitigating circumstances, and that they will be read to you. One of them, and I think there's a couple that have to do with the fact that he has no prior criminal history, and we'll talk about that in a minute. No prior felony convictions. There's also a couple, they're kind of interchangeable, that Rashad Murphy, his age at the time of the offense, he was only 30 years old when the homicide occurred. There's no dispute of this. It's there for your consideration. The state never is not disputing it. It was stipulated to. Another proposed mitigator is Rashad Murphy has a history of physical and emotional abuse as a child consistent with childhood post-traumatic stress disorder. You heard from Dr. Collins, you heard from the record from the jail doctors. I think there's certainly corroboration of that, and again, something that has not been refuted by the state. You will also hear that Rashad Murphy has maintained a loving relationship with family and friends while incarcerated. And again, you heard that from the fiance, Ms. Steger, his uncle, and his aunts. Another proposed mitigator is that Rashad Murphy has developed religious and spiritual awareness while incarcerated. In fact, you heard testimony that he was religious before, but certainly the exhibits and his family's testimony corroborate that. Also, Rashad Murphy helped raise his younger siblings, including working jobs at a young age to provide family support. Certainly that was corroborated by the records and by the testimony of his family. And the same thing with the next one, which is Rashad Murphy as a minor was removed from his primary home and placed into foster care due to negligent and abusive situations in the primary home. Also, Rashad Murphy has displayed appropriate behavior and the ability to follow rules while incarcerated. And again, that's corroborated not just by the exhibits and the records. He has been no problem whatsoever while he's been incarcerated. And that's an indication of what type of prisoner he would be if he is sent to prison for life. You also are being told the existence of any other factors in Rashad Murphy's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death sentence. And we'll get to, I will touch base on some of these mitigators, but if there's something I forgot, something that you believe in your observations or hearing, please rely on that as well. Now let's go back to some of these. His age, which is two of the proposed mitigating circumstances. He was 30 years old at the time of the homicide. He's presently 32 years of age. To some extent, I would suggest that that age is an interesting number. He's still a young man. He's still a young man. He was only 30 at the time of the offense. And it's certainly, that alone is offered as a significant mitigating circumstance. However, it also is old enough to have established a pattern, good or bad. It's certainly at the age of 30, you've been an adult for 12 years. It's certainly old enough to have become a career offender. But here we have no felony convictions whatsoever. So here we have 12 years of adulthood to look at, and we have a good pattern. With his background and environment, with the violence surrounding him, with the abuse inflicted on him, I suggest to you that it's extraordinary that he made it to the age of 30 with no criminal history. Let's go back a minute to the PTSD. As I said before, the state is not refusing the mental condition. And no state doctor testified saying, refuting the opinion of Dr. Collins. I think it's fair to say that the state is suggesting that considering everything, it's not important because you found the defendant guilty of first-degree murder. And as I said before, it's not offered as a defense, but it is presented to you as a significant mitigating circumstance for your consideration. And I think it's somewhat disingenuous for the state in their cross-examination to imply that the defendant's mental condition is normal for someone who's incarcerated. Of course, being in jail, getting arrested, got to be stressful. But that's not what we have here. The defendant's childhood is not normal. Getting abused by his father and stepfather is not normal, ladies and gentlemen. Growing up in the violent environment is not normal. Being abused at the foster home is not normal. Neglect due to his mother's addiction is not normal. Touching back briefly on his behavior while he's been in jail on this case. And as I said, it shows that he knows he's not he doesn't cause trouble at the jail. But I think it should be emphasized that he can be, in addition to having contact with his family, he can be a positive influence on other prisoners. He's been teaching Bible classes. He can mentor other inmates now in jail and later in prison. And as I said, he would, as you've heard testimony, the evidence has shown and his behavior has shown that he would continue to be able to maintain a living relationship with his family and friends while in prison. Ladies and gentlemen of the jury, all first-degree murders are not the same. That's just the bottom line. And that's a decision, a vote that you have to consider. The facts and circumstances are always different. All defendants convicted of first-degree murder are not the same. And of course, as a corollary to that, not all first-degree murders warrant a death sentence. I suggest to you that the death sentence should be reserved for the worst cases. All murders involve the death of a human being. All murders involve some level of violence. But here we don't have any torture. We don't have multiple deaths. Here, we don't have separate incidents. It was all one event, a terrible event. I mean, there's no way to describe it otherwise. A terrible event, but only one contemporaneous event. You determined justice. You determined justice was served with your verdict. As you've been told more than once, Rashad Murphy will die in prison regardless of your vote. And based on your verdict, a severe punishment is appropriate, and there's only two choices. I submit to you that justice will be served. It will be further served by severely punishing Rashad Murphy by making him spend the rest of his life, which according to normal life expectancy could be another 50 years, to spend the rest of his life in prison, to live under strict rules and regulations without the basic freedoms we normally take for granted, that we normally enjoy. And I'm trying not to be repetitious, but I need to go back for a moment to this lack of any prior felony convictions. I cannot, ladies and gentlemen, I cannot overemphasize this. Despite the terrible environment the defendant grew up in, despite those scars, despite the mental ill issues he lives with on a daily basis and will continue to live with, despite whatever treatment he gets, the defendant, Rashad Murphy, has no prior felony convictions, not one. And I ask you, when you decide on your vote, compare that fact, that stipulated fact, to a career offender. Compare that fact to someone who has a prior record of similar crimes or violent behavior. Compare that stipulated fact to the state's argument that the attempted murders serve as an aggravating factor despite being only one contemporaneous event. Compare that stipulated fact to the state's argument that an aggravating factor is that the defendant was a criminal gang member. All that, all those allegations, all those factors, despite the fact that he has no prior felony convictions. I submit to you that the mitigating circumstances outweigh any aggravating factors presented by the state. But in any event, I submit the mitigating factors clearly show that a life recommendation is warranted with respect to Rashad Murphy. Ladies and gentlemen of the jury, I have not offered this evidence or made this closing argument to in any way justify the homicide. My only point is that the evidence presented, all corroborated, demonstrates that a life recommendation is appropriate for Rashad Murphy. And finally, I want to talk about Rashad Murphy's children. 2 sons, 2 daughters, between the ages of 7 and 13. Pretty much the ages that the defendant was when he was experiencing some of this abuse and separation from his family growing up. Despite being in prison for the rest of his life, he was an excellent father, he is an excellent father, and he can still be a positive influence on his children. He has been and would continue to be a loving and supportive father. Please, please let him carry on as daddy to Major, to Avery, to Prosper and Gabrielle, guiding them to do the right thing. Thank you.
All right,
thank
so
you,
that's
Mr.
the end of the
Hernandez.
4
Okay,
arguments.
We're going to take just a quick comfort break, and then we're going to come back. I'm going to read the final set of instructions to you, okay? All right, thank you.
All right.
All right, guys, so we are real time, so we can't skip, but that was the 4 for the defense closing. Remember, there's no rebuttal closing for the state in this type of phase. So the argument that Scott Harmon did yesterday was the state's last word, and this was the last word for the defense arguments. Daniel Hernandez was the longest argument.
Okay, very good. All right, take a 2-minute break, and Ron, when they come back in, if you would hand these out to them.
Oh my gosh. Stack of papers. And you know, I was thinking deliberations might be, obviously it's of a different nature. But I'm wondering, we did hear Sisco say in my experience, they tend to be a bit quicker. And I was like, oof, hope they don't think like, let's rush this along. But if you think about it, it kind of makes sense because when you're deliberating on guilt, the jury has to be unanimous to either find somebody guilty or to acquit somebody, right? Otherwise, they're going to have to keep deliberating. They could tell the jury, hey, we're at an impasse. We can't come to a decision. What do we do? And the judge is going to tell them a few times, we'll keep trying, and maybe even give them an Allen charge, which is like a final, try to put your differences aside, go through the evidence, and try to see if you guys can come to an agreement. But here with the penalty phase, there doesn't need to be agreement. If you go in there and you're a yes, you're a yes. If you go in there and want to be sure and talk about it with people, that's one thing. If you go in there and you're a no, then you're a no. So I'm not sure that it's necessary that people need to deliberate with each other for quite as long because really the decision is individual. So I do think that this could be quicker than the guilt phase deliberation time, which when I did the count from when we started the deliberations, it was like, I forget what time in the morning, but we marked it. And when they came back at 6 o'clock local time, I marked it was either 6.5 or 7.5 hours of deliberations, depending on whether or not they deliberated through their lunch. But news articles I was reading said deliberations were 8 hours. So I'm just going to trust the news articles saying that they deliberated during the guilt phase for 8 hours to come back with the guilty verdicts. And I don't know, I think it'll be less. I think we'll have a decision today. So, and right, yep, don't forget guys, for Florida and Alabama are the only 2 states that do not require a unanimous jury for a recommendation for the death penalty. In Alabama, it's 10 out of 12, and here we are only 8 out of 12. And again, you know, I'm sure they'll want to deliberate and discuss things, but ultimately they do not have to get on the same page as one another. So it's a different kind of dynamic for this set of deliberations compared to the guilt phase. So, and yeah, I think, let's see. Yeah, I think in an hour. Let's see. Lots of discussion in the chat. Not many predictions on the time. We got another hour in here. Yeah. I mean, question of the day, right? Miss Money on my mind is like, why? Florida's crazy. Why would you do anything in Florida? Look, somehow Florida has this reputation of being tough on crime, and yet we're also the home of the quote-unquote Florida man. So, like, are we really deterring crime? I mean, I don't know. I think people are going to people. I also think being in a hot environment makes it, people are outside more in a climate that's warm year round where, you know, you don't get snowed in or anything like that. So hot weather, when I used to live up in New York, it's like as soon as summer started, like you'd start hearing stories like shootings would go up. But when it was winter, things would calm down a little bit. Nobody wanted to be outside in the cold. So yeah, we got another prediction here, 1 to 2. So Sonia says by 5 p.m. Yeah, and I think that will be the case. And I don't know how long the jury instructions reading will take, but we could stay live for verdict watch like we did last week for the guilt phase. Let me know what you guys want to watch. I saw that you guys would be interested in rewatching testimony from the guilt phase of this trial. The choices were, defense opening statements. And I only said defense opening statements because I think Scott Harmon's closing in the penalty phase was pretty similar to what he did for what we had for the opening in the guilt phase. I thought the defense arguments could be interesting because they've had to make an extreme shift from arguing my client didn't do this, the evidence is circumstantial, you don't really know if my client was there or at the actual shooting, if he was only seen at the Airbnb the next day or the next morning. And now in the penalty phase, they've had to shift gears and forget relitigating the guilt. And here's why you should mitigate your sentence and just recommend life without parole. And then the Alicia Andrews stuff was on the table as well. So very specific prediction here from Sheriff Chuck, 2 hours and 16 minutes. We're going to bookmark this, see if he gets close. We got 3 hours here. 3 hours. Heck yeah. Gangmaster Yoda, who is a hilarious name, by the way, says, I'm going to listen to this while I do some yard work. Love it. Love it. Literally in the bushes. We love those who work and lurk in the bushes, and that would literally put you in the bushes, wouldn't it? Oh, man. 2 to 4 hours. That's a wide range now, but I feel it. I feel it. I don't know. Is it I'm Eve? Like the 3 is an E, or is it like EV3? But we'll say Eve. I'm Eve thinks maybe 2. And think maybe it'll hang on Sean and Isaiah. Yeah, I mean, that could be it too. Like, what if there's uncertainty, but, for some of the defendants, there's enough jurors that already made their mind in one way or another that they don't think it's close. But what if they're like between 7 and 9 on somebody and they get stuck debating that one person? So in Florida, we are East Coast time. So this is 10:45 a.m. on the dot right now. So let's see. Their indictment paperwork. Oh, hold on. How do I make this shared? Okay. All right, there's a link in the chat to the indictment if you wanted to check that out. And really the important thing from the indictment is, I think this is worth saying too. Everyone yesterday, not everyone, but a few people are like, hey, we already know that this was premeditated murder. Why is Scott Harmon spending so much time on this? Well, the standard for an aggravating factor, right? When it comes to charges and the charging language used, someone's charged with first-degree premeditated murder. That's the guilt phase. They have to prove premeditation beyond a reasonable doubt. That in a bubble, the jury said, yes, you prove that beyond a reasonable doubt. But when you get over to the penalty phase and talk about an aggravating factor in a capital case, the aggravation has to be more specific, and you have to prove at least one aggravating factor beyond a reasonable doubt, and also find that those aggravating factors outweigh any mitigating factors. Something I think is additionally interesting, there are a list with statutory language of what could be an aggravating factor and what could be a mitigating factor. For mitigating factors, there's a blanket catch-all mitigating factor, and you heard 2 of the attorneys mention it. Daniel Hernandez talked about it a lot. If there's anything else that we're not explicitly stating to you as a mitigating factor, but that you saw and you want to take into consideration, you can do that. And we're going to hear Judge Sisco read the jury instructions. And the last mitigating factor she's going to read off, they talked about it during their jury charge conference. She's including that bubble blanket language. So even if we don't explicitly lay out something that could mitigate, like they have mental mitigation, they grew up rough, they are unable to comprehend the consequences of their actions or conform their behaviors. All of those pieces of language, there's a blanket catch-all that the defense, that can help the defense. And the state for aggravating factors does not get a blanket, well, if there's anything else you want to consider, you can to aggravate. It's only the 4 factors that they've argued. And I'll pop those on the screen real quick in case you missed them. But the standard here for the aggravating factor that all 4 are facing, they've all been convicted on count 1. But the idea that this premeditated, this capital felony, this first-degree premeditated murder that they've been convicted of, it has to be cold, calculated, and premeditated to a heightened extent with an extended cooling off period. If you want to look at that image a little more, pause the video and you can stay on it and check it out. So that's why Scott Harmon had to go through it again, because he's not just proving it was premeditated. He's got to prove in this brand new phase of a trial that it was heightened. And it's different from other first-degree murders that might occur. And thus it warrants a special sentence, this death penalty sentence. So they still have a burden, even if we think, okay, well, we already proved that they did this. That's why we've got to go through the motions. So they are not quite deliberating yet. We've got to get through jury instructions after this morning recess here. And what else? There was another question yesterday.
Council's present, state's
Forget what it
present,
was.
go ahead and bring in our jury.
Although I do think a lot of the questions will be answered while we hear these instructions. And again, you got to think, why are they arguing this stuff? We know they did it. Who cares if they grew up rough? They're allowed to, and it's the defense attorney's job to, any possible mitigating factor available, they should be trying to find somebody to come testify to such circumstances so they can argue it in their closing, right? Regardless of whether or not you think it's worth giving weight or it outweighs the aggravating factors, that's exactly the thought process the jury is going to go through. But it's their job to make those arguments. So even if it's, maybe some people thought it sounded silly to go through the motions, it's important to go through the motions. I'm going to end, we're going to do the final poll. We're going to end the one for Davion, and I'll get the Rashad one up a little late here, sorry. And we'll go over the results for all 4 after instructions.
Okay, very good. All right, I believe you all should each have a set of the final instructions before you, so you can read along while I read them to you. Members of the jury, you have heard all the evidence and the arguments of counsel. Now you must decide whether each of these defendants should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must not consider any other facts as an aggravating factor other than what has been alleged and proven by the state beyond a reasonable doubt. The aggravating factors alleged by the state as to defendant Isaiah Chance are, number 1, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. Number 2, the first-degree murder was committed by a criminal gang member. The aggravating factors alleged by the state as to defendant Sean Gathright are: 1. Sean Gathright was contemporaneously convicted of a felony involving the use of violence to another person. 2. Sean Gathright knowingly created a great risk of death to many persons. 3. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And again, the definitions are the same with regards to cold, calculated, premeditated, and pretense of moral or legal justification. The aggravating factors alleged by the state as to defendant Rashad Murphy are: number 1, Rashad Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Number 2, Rashad Murphy knowingly created a great risk of death to many persons. 3, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And again, the definitions of cold, calculated, premeditated, and pretense of moral or legal justification are the same. Number 4, the first-degree murder was committed by a criminal gang member. The aggravating factors alleged by the state as to defendant Davion Murphy are: number 1, Davion Murphy was contemporaneously convicted of a felony involving the use of violence to another person. 2, Davion Murphy knowingly created a great risk of death to many persons. 3, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And again, the definitions of cold, calculated, premeditated, and pretense of moral or legal justification are the same. Number 4, the first-degree murder was committed by a criminal gang member. You have heard evidence about the impact of this murder on the family of Charles Jones. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by the death of Charles Jones. However, you may not consider this evidence as an aggravating factor. The state has the burden to prove an aggravating factor beyond a reasonable doubt. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction it is one which is not stable but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each of the alleged aggravating factors exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether you find that each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt as to a defendant, then that defendant is not eligible for the death penalty, and your deliberations are complete. If, however, you unanimously find that at least one aggravating factor has been proven beyond a reasonable doubt as to a defendant, then that defendant is eligible for the death penalty, and you must consider additional matters to determine whether the appropriate penalty should be life in prison without the possibility of parole or death. First, each of you must determine whether any mitigating circumstances exist. A mitigating circumstance is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of a defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not appropriate in this case. It is a defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances need not be proven beyond a reasonable doubt. Instead, a defendant need only prove a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it proven and give that evidence such weight as you determine it should receive. You need not reach a unanimous decision about whether a defendant has proven the existence of a mitigating circumstance. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are mitigating circumstances as to defendant Isaiah Chance. Number 1, Isaiah Chance's age at the time of the offense. 2, Isaiah Chance has no significant history of prior criminal activity. 3, Isaiah Chance was 21 years old at the time of the offense. 4, Isaiah Chance suffers from borderline intellectual disability as well as untreated attention deficit hyperactivity disorder, also known as ADHD. 5, Isaiah Chance's decision-making was impaired by his borderline intellectual disability and ADHD. 6, Isaiah Chance did not personally carry, display, use, threaten to use, or attempt to use a firearm during the commission of the offense. 7, prior to this case, Isaiah Chance had never been arrested. 8, Isaiah Chance cherishes fatherhood and has a great relationship with his 3 children. 9, Isaiah Chance has a loving and very close relationship with his parents, siblings, grandmother, and godmother. 10, Isaiah Chance helped his grandfather and grandmother when his grandfather had cancer. 11, Isaiah Chance attended church with his stepfather and his grandmother. 12, Isaiah Chance helped his mother around the house. 13, Isaiah Chance was motivated and preparing for a career as a merchant seaman. 14, Isaiah Chance was described as a quiet, respectful, and nonviolent child by family members and friends. 15, Isaiah Chance has the continued support of many family members and friends. 16, Isaiah Chance is a son, brother, grandson, and father whose life has meaning to others. 17, Isaiah Chance is capable of growth, redemption, and maturity because of his young age. 18, the existence of any other factors in Isaiah Chance's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Mitigating circumstances as to defendant Sean Gathright. Number 1, Sean Gathright has no significant history of prior criminal activity. Number 2, Sean Gathright's age at the time of the offense. 3, Sean Gathright was 18 years old at the time of the offense. 4, Sean Gathright was raised in a military family with repeated parental deployments, resulting in frequent relocations and prolonged separations from both of his parents. 5, Sean Gathright was primarily raised by his paternal grandmother due to parental absence and instability throughout his life. 6, Sean Gathright lacked a stable male role model or consistent guidance during formative years while he was a teenager. 7, Sean Gathright was subjected to verbal abuse by his father. 8, Sean Gathright was subjected to physical abuse and injury at the hands of his biological father. 9, Sean Gathright lived in an environment marked by fear, conflict, and lack of safety in his father's home. 10, Sean Gathright struggled with identity formation and belonging in adolescence. 11, Sean Gathright experienced isolation and difficulty adjusting socially after relocation in adolescence. 12, Sean Gathright was highly susceptible to influence due to his age. 13, Sean Gathright's decision-making was influenced by peer groups and an unfamiliar culture. 14, Sean Gathright is described as kind, respectful, and nonviolent by family and friends who know him. 15, Sean Gathright is optimistic and a positive support for family and friends. 16, Sean Gathright loves his sister, nephews, mother, grandmothers, and friends. 17, Sean Gathright is loved deeply by the family who have supported him. 18, Sean Gathright has been described as calm, well-mannered, and non-confrontational. 19, Sean Gathright has the capacity to contribute positively to those around him. 20, Sean Gathright is a son, brother, grandson, and friend whose life has meaning to others. 21, Sean Gathright is capable of growth, redemption, and maturity because of his young age. 22, Sean Gathright has the desire and potential to mentor and positively influence others, particularly younger individuals in prison. 23, Sean Gathright fed the homeless and was very involved in community projects in Mississippi when he lived with his paternal grandmother. 24, Sean Gathright traveled to foreign countries on mission trips for humanitarian purposes. 25, Sean Gathright participated in educational international travel programs reflecting exposure to broader opportunities. 26, Sean Gathright demonstrated entrepreneurial initiative, including running small businesses, pressure washing, detailing, and photography. 27, Sean Gathright showed motivation and productivity at a young age. 28, Sean Gathright has demonstrated the desire to be productive by taking courses in an incarcerative setting. 29, Sean Gathright engaged in creative and constructive outlets, including photography and media work. 30, Sean Gathright has shown resilience and adaptability despite adversity. 31, Sean Gathright can contribute significantly to the prison workforce. 32, the existence of any other factors in Sean Gathright's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Mitigating circumstances as to defendant Rashad Murphy. Number 1, Rashad Murphy has no significant history of prior criminal activity. Number 2, Rashad Murphy's age at the time of the offense. 3, Rashad Murphy was only 30 years old when the homicide occurred. 4, Rashad Murphy has a history of physical and emotional abuse as a child, consistent with childhood post-traumatic stress disorder. 5, Rashad Murphy has maintained a loving relationship with family and friends while incarcerated. 6, Rashad Murphy has developed religious and spiritual awareness while incarcerated. 7, Rashad Murphy helped raise his younger siblings, including working jobs at a young age to provide financial support. 8, Rashad Murphy loves his children and has been a good father to them. 9, Rashad Murphy, as a minor, was removed from his primary home and placed into foster care due to negligent and abuse situations in the primary home. 10, Rashad Murphy has no prior felony convictions. 11, Rashad Murphy has displayed appropriate behavior and the ability to follow rules while incarcerated. 12, the existence of any other factors in Rashad Murphy's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Mitigating circumstances as to defendant Davion Murphy. 1, the capacity of Davion Murphy to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. 2, the capital felony was committed while Davion Murphy was under the influence of extreme mental or emotional disturbance. 3, the age of Davion Murphy at the time of the offense. 4, Davion Murphy suffers from traumatic brain injury. 5, Davion Murphy was exposed to repeated violence in his childhood and young adult life. 6, Davion Murphy is in the borderline range of intellectual disability. 7, Davion Murphy grew up in a household marked by instability and financial strain. 8, Davion Murphy did not have a stable male role model in his life. 9, Davion Murphy's father was diagnosed with schizophrenia. 10, Davion Murphy's father was incarcerated for life when Davion Murphy was 12 years old. 11, Davion Murphy took on a parental role for his younger siblings. 12, Davion Murphy is loved by his family. 13, the existence of any other factors in Davion Murphy's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. The final step in the process is for the jury to determine whether a defendant should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must weigh all of the following factors. 1, whether sufficient aggravating factors exist, and 2, whether the proven aggravating factors outweigh the proven mitigating circumstances. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance. Regardless of the result of each juror's individual weighing process, even if you conclude that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to recommend that a defendant should be sentenced to death. If fewer than 8 jurors vote for the death penalty for a defendant, the court must sentence that defendant to life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty for a defendant, your recommendation for that defendant must be for the death penalty. This recommendation is not binding on the court. However, I am required to assign and give great weight and deference to your recommendation. You will be provided forms to reflect your decisions. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that human life is at stake, and bring your best judgment to bear in reaching your decisions. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? And 9, has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. Defendant Sean Gathright has become a witness in this case. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. It is entirely proper for the lawyers to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to the lawyers about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its aggravating factors against the defendants. It is not necessary for a defendant to disprove the aggravating factors. It is up to the state to prove the aggravating factors by evidence. Defendants Isaiah Chance, Rashad Murphy, and Davion Murphy each exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of any kind or be influenced in any way by this decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Criminal gang member applies only to defendants Isaiah Chance, Rashad Murphy, and Davion Murphy. Criminal gang means a formal or informal ongoing organization, association, or group that has as one of its primary activities the commission of criminal or delinquent acts, and that consists of 3 or more persons who have a common name or common identifying signs, colors, or symbols, including but not limited to terrorist organizations and hate groups. Criminal gang member is a person who meets 2 or more of the following criteria. 1, admits to criminal gang membership. 2, is identified as a criminal gang member by a parent or guardian. 3, is identified as a criminal gang member by a documented, reliable informant. 4, adopts the style of dress of a criminal gang. 5, adopts the use of a hand sign identified as used by a criminal gang. 6, has a tattoo identified as used by a criminal gang. 7, associates with 1 or more known criminal gang members. 8, is identified as a criminal gang member by an informant of previously untested reliability, and such identification is corroborated by independent information. 9, is identified as a criminal gang member by physical evidence. 10, has been observed in the company of 1 or more known criminal gang members 4 or more times. Observation in a custodial setting requires a willful association. It is the intent of the legislature to allow this criterion to be used to identify gang members who recruit and organize in jails, prisons, and other detention settings. 11, has authorized any communication indicating responsibility for the commission of any crime by the criminal gang. Rules for deliberation. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. 3, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 4, your duty is to determine whether the appropriate sentence in this case is life in prison without the possibility of parole or death. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. The verdicts must be in writing, and for your convenience, the necessary verdict forms have been prepared for you, and they are as follows. Defendant Isaiah Chance, jury verdict form, penalty phase. We, the jury, find as follows as to Isaiah Chance in this case. A, aggravating factors. 1, we, the jury, unanimously find the state proved beyond a reasonable doubt that Isaiah Chance committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. the premeditated intent to kill must be formed before the killing. However, for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. And you would check yes or no. 2, we the jury unanimously find the state proved beyond a reasonable doubt that Isaiah Chance was a criminal gang member at the time of the homicide. Again, check yes or no. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations. The foreperson should date and sign at the end of this form. If you, the jury, answered yes as to any aggravating factor listed, proceed to Section B. Section B, jury recommendation. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. Check only 1. We, the jury, have unanimously found the state proved 1 or more aggravating factors. Each of us has considered whether 1 or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Isaiah Chance should be sentenced to life in prison without the possibility of parole. We, the jury, find Isaiah Chance should be sentenced to life in prison without the possibility. Oh, okay. Let me back up. We have further considered whether Isaiah Chance should be sentenced to life in prison without the possibility of parole or death. And then you would check one of the following 2. We, the jury, find Isaiah Chance should be sentenced to life in prison without the possibility of parole. Or we, the jury, find by a vote of blank to blank, and you would fill that in, that Isaiah Chance should be sentenced to death. Dated this blank day of May 2026 in Hillsborough County, Florida, and there's a line for the foreperson of the jury to sign and print their name. As to defendant Sean Gathright, jury verdict form, penalty phase, we the jury find as follows as to Sean Gathright in this case. A, aggravating factors. 1, we the jury unanimously find the state proved beyond a reasonable doubt that Sean Gathright committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And then the definitions I've already read to you regarding cold, calculated, premeditated, and a pretense of moral or legal justification. Again, you would check yes or no. 2, we the jury unanimously find the state proved beyond a reasonable doubt that Sean Gathright created a great risk of death to many persons. And again, you would check yes or no. Number 3, we the jury unanimously find the state proved beyond a reasonable doubt that Sean Gathright was contemporaneously convicted of a felony involving the use of violence to another person. Again, check yes or no. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations. The foreperson should date and sign at the end of this form. If you, the jury, answered yes to any aggravating factor listed, proceed to Section B. B, jury recommendation. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. Again, check only 1. We, the jury, have unanimously found the state proved 1 or more aggravating factors. Each of us has considered whether 1 or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Sean Gathright should be sentenced to life in prison without the possibility of parole or death. And again, you check one of the 2. We, the jury, find Sean Gathright should be sentenced to life in prison without the possibility of parole, or we, the jury, find by a vote of blank to blank that Sean Gathright should be sentenced to death. Defendant Rashad Murphy, verdict form, penalty phase. We, the jury, find as follows as to Rashad Murphy in this case. Aggravating factors. Number one, we, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And again, the definitions are included there, and they are as I have instructed you previously. And you would check yes or no. Two, we, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy created a great risk of death to many persons. Again, check yes or no. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Again, check yes or no. Four, we, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy was a criminal gang member at the time of the homicide. Again, check yes or no. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations. The foreperson should date and sign at the end of this form. If you, the jury, answered yes to any aggravating factor listed, proceed to section B. B, jury recommendation. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. And again, you would check only one. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Rashad Murphy should be sentenced to life in prison without the possibility of parole or death. And again, you check one. Either we, the jury, find Rashad Murphy should be sentenced to life in prison without the possibility of parole, or we, the jury, find by a vote of blank to blank that Rashad Murphy should be sentenced to death. Gave this blank day of May 26 in Hillsborough County, Florida. Again, lines for the foreperson to sign and print their name. Defendant Davion Murphy, verdict form penalty phase. We, the jury, find as follows as to Davion Murphy in this case. A, aggravating factors. 1, we, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And again, the same definitions apply as I previously instructed you, and you would check yes or no. 2, we, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy created a great risk of death to many persons. Again, check yes or no. Number 3, we, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Again, check yes or no. 4, we, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy was a criminal gang member at the time of the homicide. Again, check yes or no. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations. The foreperson should date and sign at the end of this form. If you, the jury, answered yes to any aggravating factor listed, proceed to section B. B, jury recommendation. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. And you'll only check one. We, the jury, have unanimously found that the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Davion Murphy should be sentenced to life in prison without the possibility of parole or death. And again, you check one of these. We, the jury, find Davion Murphy should be sentenced to life in prison without the possibility of parole, or we, the jury, find by a vote of blank to blank that Davion Murphy should be sentenced to death. Dated this blank day of May 26 in Hillsborough County, Florida. Again, signature and lines for the foreperson to sign and print their name. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson, and you keep the same foreperson if you decide, who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when your deliberations are concluded and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case until you have reached a verdict. You must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items are received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Okay, so does anyone have
7
any
o'clock.
electronic devices in the, okay, so you guys kind of know the drill. Juror 168, Mr. M.N., do you have anything in the jury room that you need to get out? Okay, so this is the same as last time, right? So you guys we're going to go into the jury room. Do not begin discussing anything about this case until our alternate has left and until the bailiffs have left. You will receive all of the evidence that was submitted, and you will also receive, the bailiffs will bring in the actual final verdict form. Each of you, again, were given a copy for your own use, but the official verdict form will be the stapled copies that the bailiff brings in, and that's what you all are to utilize. Okay, very good. So I'll talk to our alternate after you grab your items. If you have any electronic devices on you now, anything, leave them in your chair. Otherwise, the bailiff will collect them and bring them out here.
All right.
All right, so we're going to start the clock. It's like a minute after 11:31. We'll say 11:31. I don't know. I know they need time to like get into the room physically, but we'll just say 11:31.
Okay. I just want to thank the attorneys for the state, Mr. Harmon, Ms. Ismer, Ms. Doherty, Mr. Hernandez, Mr. Gonzalez, Ms. Finkelstein, Mr. Sonardes, the various Sonardes, Mr. Petredis, Mr. Bolt. You all are just the height of professionalism and ethics, and it really is a pleasure to have you in my courtroom. I never, ever have to worry that any of you are going to violate the rules or treat each other disrespectfully or treat me disrespectfully, and it really just makes my job simpler. So I do appreciate it. So I just want to commend you all for that. Thank you. Okay, so I don't even really have the words to thank you for your service. It's such a hard thing in these cases, particularly cases of this magnitude that take this long. and we have alternates, and you have to sit and listen to all the evidence, and then we tell you, surprise, you don't actually get to partake in the decision. But I do hope you realize how critically fundamental you are to the process. As we discussed before, in these cases, we have to have 12 people decide these verdicts. And if something happened and we didn't have an alternate, we'd have to start all over. And you now very well are very familiar with all that goes into these cases. So I just want to thank you on behalf of everyone, on behalf of the citizens of Hillsborough County. Thank you so much for your service. And the good news is you are now released from your jury service. You're free to talk to whoever you would like to about the case. You're free to stick around. You're free to go. And again, just thank you so very much. Thank you.
So we are officially on verdict watch. Let's see. I think we are officially on verdict watch.
Okay, so we'll be in recess pending a verdict.
Or a question, but yes. All right, so I have my clock. We'll say they got sent at 11:31 a.m. The banner is updated. You guys voted in the chat to rewatch the testimony of Sean Gathright's mom from Alicia Andrews' trial, which might be especially interesting after seeing her testimony in the penalty phase here. So I've got that queued up. And guys, the way verdict watch works, last time the verdict came in very, very quickly. I tried to send out a tweet or whatever, a post on X. I'm never going to not call it a tweet. I can call it X, but I can't not call the posts tweets. So I'm going to give you my link there. If you do use X, that's probably the quickest place to get a notification that there's a verdict, so you can pop back in. So there's a link to that in the chat. It should also be in the description. But yeah, we're going to stay live. We're going to rewatch some trial testimony like we did last week while we wait. And again, it is my prediction that this would be faster than deliberations from last week, but that's just my guess. I can't promise anything. I don't know. I have no idea. These jurors could take a week and who knows. But I just think this one will be a little bit quicker. We do have a poll. Also, if you guys want to hit the like button, that would be great. And we're going to say this verdict watch is sponsored by all those who sent in their chats, their thoughts, became members today. So shout out to you guys. Thank you so much for the support. We had Ivy League come in with the 5 and no comment, just the 5. So big thank you starting us off. Renee Stevenson with some food for thought. So weigh in, you guys. Renee says, morning, Kat. I couldn't find them guilty just based on the fact they didn't go after an innocent man. And remember, that's something the jurors can consider this blanket mitigating factor in this part of the phase. So maybe that's something that other jurors could be thinking about, just like Renee is here. And I've seen some other people say similar things in the chat, and the opposite, right? It shouldn't matter. Renee says their lives and families' lives on both sides are destroyed, and it's sad. And some personal reflection here, and just so you guys can see me. You guys have heard me say I'm ideologically opposed to the death penalty, so I could never have sat on this trial, right? It's got to be the same jury for the guilt phase and the penalty phase, so I would not have been seated. They would have excluded me as soon as I said I'm ideologically opposed. I would have told them the truth. But if not, they could watch me on YouTube and be like, do you have a YouTube channel where you've said, you know, you don't really know how you feel about the death penalty? They would get me gone real quick. But all that being said, I still like to consider, like, putting that aside. Like, okay, I can see these aggravating factors are on the table. 2 of the aggravating factors don't even need to be reproven beyond a reasonable doubt in this phase, because it's the same language as the findings in the guilt phase. The contemporaneous convictions of violence to other persons, so those attempted murder charges, and the for the benefit of the gang. So those aggravating factors, the contemporaneous applies to Davion, Rashad, and Sean. And the gang membership doing this for the benefit of the gang applies to Isaiah, Davion, and Rashad. Right? So those factors, you know, the state only needs to prove one aggravating factor beyond a reasonable doubt for the jury to be able to recommend the death penalty. Of course, the jury can decide, look, even though we believe these aggravating factors were proven beyond a reasonable doubt, we find that the mitigating factors outweigh those aggravating factors, right? So just because an aggravating factor is proven beyond a reasonable doubt doesn't mean that they will put forth the recommendation, but they can. if they decide that the mitigating factors aren't enough. So, even though the state has the burden, they kind of came in with, a heavy starting point because of the verdict, including that gang language in the charges and also the attempted murder convictions. So going back to Renee's thoughts here, going through this, I like to analyze those things. I still like to think about it, even though I would never be on this jury. I still think if I would be back there, I'd be like, hey, yeah, I do think that these aggravating factors are met. Now let's talk about the mitigators. What do we think? And something that really became a new perspective for me in this trial, Adventure Aaron was in the chat and mentioned, some statistics on what happens to family members who have a loved one that's incarcerated, and started looking up death penalty statistics, information. What are the costs? And we went through some of it, I think, on the day 2 stream for the penalty phase. And I never really gave it too much thought, but I do feel like sentencing somebody to death could really impact the friends and family members. And that's part of the reason why they're called to testify, to show that if you execute somebody, it would be punishment to these individuals who are not on trial for these crimes, who have not been convicted for these crimes. There are children that would wonder, it's the other option is they have a parent who is incarcerated for the rest of their life. So the child would still have to deal with some loss of a parent. But I think it's a little bit different. It's something more profound and significant, in my opinion, to imagine, and I never experienced it, but I don't know what it would be like to be 5 years old and my mom or dad is executed. So it's just been something I've been thinking about at night, late at night, and it's kind of a heavy thing to think about. Not really something I was considering before going into this. It was just morally opposed. So I don't know if you guys have had any new thoughts come across your mind, but would love if you shared that in the chat. But I agree, like this family aspect is something that I gave more thought to this trial than before going into it, because I've never watched a penalty phase before. Renee also says, hopefully Sean and Chance will be able to teach the youth they cross paths with. And I'm wondering, like, I really wonder, some jurors feel like because of the age, if they're going to split, maybe some jurors feel like Sean and Chance are the ones to save. And maybe some others think Rashad and Davion are the ones to save. And I don't know how to feel about a split. I don't know if I think they're going to go, either they're all going to get DP or they're all going to be spared, or they're going to split it. I just have no idea. So it seems like Renee thinks here that Sean and Chance at least will be spared. Derek, thank you for the super sticker. Thank you for always showing the love. Renee also says, I think Chance's lawyer gave the best closing argument today. Who did you guys like the best for closing? I actually, just from a legal standpoint, I appreciated Daniel Hernandez, just because he opened by listing out very clearly the mitigating factors, and he did it in a way that matches the jury instructions. And it might not seem as emotional, right? But I think there's something that in the human mind, when you hear something and then you see the same language somewhere else on the piece of paper that's guiding you in your deliberations, I just think, just on a subconscious level, that's important. You're like, oh, I remember hearing those same exact words. So I thought it was effective just for him to plainly state the list of mitigating factors in his opening and then repeat them in the closing. But yeah, I think all the attorneys did what they needed to do, and they cannot change the underlying facts or convictions that they're stuck with for this phase of the trial. So that being said, though, I think Chance's demeanor, very soft-spoken, probably better to speak about sympathetic things. And maybe he could have used a little more oomph in the guilt phase when you're still arguing and disputing that, hey, this isn't what happened at all. So thank you for the 5. Mama Girl here with the 2. Thank you. Thank you right back. Soap became a member. Thank you for becoming green. 773 Pisces, you guys showed a ton of love. Thank you so much for showing love to 773 Pisces. She gifted 5 memberships, which is a great way to support the channel. So thank you. And also very fun. I love to see you guys use the channel emojis. We have a lot of fun with them here. And then Marquita here said good morning. So everyone say good morning to Marquita. And with that being said, guys, you guys wanted to rewatch. Do I have the right? Sorry, I had a few tabs open. So I think this is the right one. Yeah, okay. Yep. So here we go. I have it queued up. This is going to be from, how long ago is this? October 30th. So this was the day before deliberations in the Alicia Andrews trial. Remember, they were deliberating and returned a verdict on Halloween. So this is October 30th, 2025, day 7, and we're going to rewatch Sean Gathright's mom's testimony. So here we go. Got a good old Snapple.
Right, swinger.
And Aaron just shared a link in the chat from the bushes on the impact on young family members who lose someone to execution.
Her face is not to be broadcast.
Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you.
Yes.
All right, so yeah, sorry to talk over the court there, but I think if you're interested in a perspective on the impact of an execution on like a non-perpetrator family member, someone who had no hands in the crime, they're just someone who's losing a family member who was convicted of a crime. Aaron shared a link that says their dads were on death row in Missouri. Here's how they faced goodbyes, executions, and grief, and it's from the Marshall Project. So Aaron's always here with the links, even when she's in the bushes lurking. So thank you for always bringing a ton of helpful resources in. I forgot. So guys, remember they approached here because the state wanted to ask to do a voir dire, which means they want to ask some questions of this witness, Sean Gathright's mom, to see if she's been watching trial testimony before she takes a stand here, which she wasn't supposed to be doing because she was on the witness list. So that's why they approached here.
Promise, just momentarily.
All rise.
Okay.
All jurors now, Judge.
Who's doing the cross for the state?
I am, Your Honor.
Okay, what do you, have a seat. I think the state wants to talk to you about any information you may have. Go ahead.
Ma'am, have you been watching the televised portion of this trial?
Yes,
And have you been relaying what you've been watching with your son?
a summary, yes.
And what is the name of your son? You communicated to him what has been going on throughout.
And they said Sean Gathright there. I think the camera person just muted because they've been on reflex trying to mute names and didn't think quick enough to realize it was going to be the name of the defendant and not some random person.
The duration of the trial.
Yes.
Were you instructed by the defense not to watch the trial?
Well, I started that before. I wasn't originally supposed to testify. So once I got the subpoena, then I stopped that.
When was that?
I want to say late last week, early this week, something like that.
Well, when was the last time that you communicated with your son about testifying or what has occurred in court?
Probably about 2 days ago.
And was that after or before your subpoena was received?
That was after.
But you have not received any kind of notification or instruction not to watch what's going on?
I have
TV?
subsequently.
When?
It was a few days ago.
You don't recall
I have
when?
to, not the specific day, it was a couple days ago.
And thereafter, you did not watch anything?
Correct.
And whatever was being televised, was that the live stream or news media that you were
It was
observing?
news media.
Did you have an opportunity to meet with the defense team about preparing for trial?
I spoke with them on the phone yesterday.
And were you the only person present for that preparation?
Yes.
Have you talked to your daughter, Nevaeh Gathright, about trial?
Not really, no.
About what's happened in trial?
No.
And have you been present for three-way conversations where you and your son were discussing that with Nevaeh on the phone? Ms. Gathright on the phone?
No.
Okay. I don't have anything else, Ron.
Okay. All right. Now you know. Let's go. Bring the jury.
All rise.
Okay, very good. Everyone have a seat again, and you may proceed, Mr. McCormick.
All right, good. All right, could you tell us where you, don't, not the address, but could you tell us where you currently live?
In Jacksonville.
All right, and do you know an individual named Sean Gathright?
Yes, that's my son.
Okay. You've known him his entire life?
Yes.
And did he live with you at any point in time?
Yes.
When did he stop living with you?
I mean, prior to this incident, he lived with me pretty much the whole time, except for 1 year he was in California with his dad.
Okay. Do you have a military background?
Yes, I do.
With what branch?
Retired Marine Corps.
And how long were you in the Marine Corps?
16 years.
All right, and do you have any firearms trainings
Yes.
with the Marine Corps?
Yes, I have both. I'm a 7th Award rifle expert with the rifle, and I also am trained in the 9mm Glock pistol.
Okay. Do you own any firearms?
Yes, I do.
How many firearms do you own?
I own several. Do you want me to include the ones that were confiscated also?
Correct. So you can just
Alright.
list all of them and then we can identify what was
Okay.
taken.
So I have a shotgun, a 30-06 rifle, and a 45 revolver. What else? And then I had the 2 ARs that were taken and another 9mm. I also have a 380, and then I have since replaced my ARs that were taken with another AR and a SIG 9mm.
All right. So including the 2 that were taken, you have about 9 or so?
Yes, about that.
All right. And you've had these firearms for how long?
The new AR and the SIG I just bought in the past couple months. The other weapons I've had mostly since between 2012 and 2015 when I was stationed in Jacksonville, North Carolina.
All right. How long have you had the 2 firearms that were taken from your house?
Those 2, I got those at a gun show in Jacksonville, North Carolina, so I would say 10, 11 years, 12 years, somewhere around there.
And those that were taken, they were taken by Jacksonville Sheriff's Office?
Yes, they were.
All right. Was there a search warrant conducted at your home?
Yes, there was.
And during that search warrant, did someone read the search warrant to you?
I don't recall.
All right.
They kind of,
Did the Jacksonville Sheriff's Office search your entire home?
as far as I know, they told me I couldn't go in or anything.
So you weren't actually inside when the search
No.
was conducted?
No.
All right.
They made me sit outside.
All right. I'm going to show you what's in evidence as States Exhibit 53, A through X. Do you see this image?
Yes, that's the sink.
Is that the sink in your house?
Yes.
The kitchen sink? And that sink, what's inside the sink?
On the left side are dishes, on the right side are cardboard.
Who put the cardboard in the sink?
I did.
For what?
I told the detective, I have a garden in the back where I have eggplants, tomatoes, and things like that. My mom said it's a good fertilizer or compost. So I'm supposed to break it down. You soak it for like 2 or 3 days, break it down, and then use it as like fertilizer. Sometimes like carbon or something. She also grows a lot of fruit trees and stuff, so she has good ideas.
Understood. And you told that to the police?
They didn't ask me about it.
All right. The items, the cardboard, what is the cardboard made of? I'm not sorry, what is it not made of, but what is it of?
It was various different things, Amazon boxes, various boxes that were in the house.
All right. Did any of it include boxes of weapons that were purchased?
It is possible.
Do you know how long you had these items in the sink?
It was only like 2 or 3 days, I think. You're supposed to soak it for 2 or 3 days so it breaks down easier. But you gotta peel the plastic, the coating, if it's not all cardboard, you gotta peel that
Is
off.
there a question posed, Your Honor? Objection?
Yep, ask a question, please.
Do you know what this is?
Not off the top of my head, no.
Do you see any cardboard that came from either a firearm or firearm part?
I believe the Mac tools, and I can't see. I don't know what that blue, can't really tell what that blue one is.
All right. The home, did the home have, other than just the firearms, did it have any ammunition in it?
Yes.
All right. And what types of ammunition did you have in the home?
I have ammunition for every single type of weapon that I have.
Okay.
So I have shotgun shells, I had 9mm rounds, 5.56s, 223s, 45, so on and so forth.
Where do you keep the firearms that you do have?
The firearms are in a safe in my master bedroom.
The safe, how do you get into it?
It's either a combination code or a key.
Showing what's in evidence as States Exhibit 54A through CCC. Is that a photograph of the master bedroom?
Yes, it is. It's right next to my chest of drawers.
All right. That safe, you said has a key or a lock?
It has a combination lock, and you can open it with a key. I usually use the key because I can never remember the combination.
All right. Is the combination anywhere? Like, did you store
No,
it
it's not
somewhere?
written down anywhere. That's why I always forget it.
All right. And the key, where do you keep the key?
The key's kept on my dresser in like an oval trinket box where I have like loose change, pens, old gift cards, like random things.
All right. Does anyone know where you keep the key for your safe?
No.
Showing 54D. Is that the inside of your safe?
Yes, it is.
And how did the police get inside the safe?
I gave them the key.
Is this also the inside of the safe?
Yes, it is.
Are these rifles equipped?
That's without the think my ARs are in that picture.
Showing 54 Gs.
Okay, yeah, I can see now.
Now, are these rifles equipped with brass catchers?
The ARs are. The brass catchers go on the ARs.
All right. And who purchased the brass catchers?
I did.
For what purpose?
For picking up, well, preventing me from having to police brass when I go to the range.
When you say police brass, what do you mean by that?
Well, when you go firing at a range, you're supposed to basically pick up all the brass that you've used in your lane and either take it with you or recycle it. And after all my years on firing ranges in the Marine Corps, you're picking up hundreds and hundreds of pieces of brass. So it's just, when I found out about the brass catchers, I was like, oh, that's heaven.
Okay. Now, did Sean Gathright own any firearms that you know of?
No,
Did you ever let him borrow any of your firearms?
no.
Had you ever taken him to the gun range?
Yes, he's been to the range with me once.
The one time that he went to the gun range with you, do you know what he fired?
We took the shotgun and we took the 45. I don't believe we took the ARs because it wasn't like a long distance range. So we mostly picked the short range weapons.
Okay. And what do you call short range weapons?
The handguns, the 9mm and the 45.
Showing 54 VV, is that also the safe?
Yes, that's all for the safe.
And showing 54 WW, is that inside of the safe?
Yes, that's also inside of the safe.
And
Sorry.
is that ammunition that we see there?
No, those are empty magazines right there.
Oh, they're empty?
Yes, those are empty right there. The ones on the right, I can't tell the ones on the left because they're not turned around where you could see where you put the rounds in, but the ones on the right that are stacked horizontally and then the two right there in the middle, those are empty.
Okay. Do you know Alicia Andrews?
No,
Do you know if Alicia Andrews has ever been to your home?
I don't, not that I recall, no.
So you're not aware of whether Sean Gathright and Alicia Andrews are friends?
I wouldn't think so because my son is friends with a small group of people and they're the ones that are at the house. I don't believe I've seen her at my house before.
All right. And when your son was arrested, he was how old?
He was 18.
Do you know of Sean Gathright to be in a gang?
No,
Do you know of him to hang out with any gang members?
no,
And do you know who Isaiah Chance is?
yes,
All right. Does Isaiah Chance ever come by the house?
yes,
When he came by the house, will you ever bring a girl with him?
no,
Did Isaiah Chance ever date your daughter?
yes.
And you never met Alicia Andrews through Isaiah Chance even?
I really can't recall specifically meeting her. I believe she may have come over when I had like a barbecue or something,
Okay.
but I'm not really, it doesn't stand out in my memory having met her.
Okay. Do you know of Isaiah Chance as the name Gutta?
No,
You never heard that before?
no.
Do Isaiah Chance and Sean Gathright call each other little or bigger bro?
Yes,
All right. Who is the bigger bro in the two?
Zay is the bigger bro, Sean's the little bro.
All right. The cars that you had at the home.
Yes.
Could you describe what cars you had?
At that time, I had a 2018 Lincoln MKZ. I had a Nissan Altima, the Chevy Impala, and a Toyota 4Runner.
The 4Runner, was it always at your home?
The 4Runner goes back and forth. I've had it since 2004, and I usually let my mom goes back and forth between New York and Florida, so she'll spend maybe 6 weeks to 2 months in each place. So when she's down here in Florida, that's a vehicle I usually let her use because that's the one that she's most used to. When I was stationed overseas for 3 years, that's the vehicle that I left for her to use. So that's what she's comfortable with.
All right. For any reason, would you lie for Alicia Andrews?
No,
Do you know who she is?
no,
Do you have any sort of allegiance to her?
no.
All right. No further questions.
Okay, Cross?
Please, Your Honor.
Yes, I'm sorry, we do need to put the witness's name on the record, including spelling.
Shout out to Allie B here. She said, personally, it's hard for me to get there with these guys, the four, because of their age and the fact no prior record. And remember, guys, even though we can make inferences about the shell casings found in the 4Runner, which is coincidentally what we're talking about here, you know, it's not technically a conviction. We don't have, that there were no charges for that. We don't have a conviction. So technically, you know, when the attorneys were arguing no prior record for whichever client, that's the argument. But I don't know if the jury could remove from the back of their mind that, hey, there are these casings found that had a knife and hit that tie back to this October 2023 attempt on Julio Foolio's life. So, but who knows, right? But technically, they were able to make the argument, no priors. And here Ali B says, I felt 100% okay with Tanner Horner getting the death penalty, though, for what he did to Athena. Now, if you missed that case, that was the case with the FedEx driver who abducted a little girl and like killed her in the FedEx vehicle. So if you saw that story come across your feed, or if you followed it and have some thoughts on that, share them in the chat. That took over the news for a while, and I believe that was over in Texas, right? Where he's sentenced to death as well. So thank you, Ali B. Also, Fran Drew, my favorite profile picture to see pop up in the chat. It says, many lives lost, literally and figuratively. It's sad. Yeah, and I've said it before, but I wonder if there'd be any closure had this happened in Jacksonville, if they didn't have these license plate readers tracking their whole journey over the river and through the woods to Tampa. Dora the Explorer, perfect picture for this, this commentary here. And if it just happened in Jacksonville, if one, they would have been caught, two, if it would have been pursued by law enforcement there, the same way that Tampa seemed to pursue it. I don't know, it just seems like there's a lot unsolved. And maybe it's because of the resources and efforts going into trying to solve things in Jacksonville, or it's not as easy to trace when you're not taking this elaborate out-of-town trip where you're being tracked and leaving a paper trail everywhere you go, right? There's layers there. But still, a lot of lives lost, and, you know, it seems like this is we have the Ksoo conviction and his plea deal, but it doesn't seem like everything's been solved. I don't know. And I think that's sad to not have closure. So thank you for being a member for 21 months also.
Ma'am, how long have you lived in the residence that you were in now?
10 years.
Did you always keep a gun safe just like that with your firearms in it?
We bought the gun safe in, I want to say 2017 or 2018.
You brought this gun safe in 2017 or 2018?
Yes.
And you have a problem remembering the code to that gun safe?
Yes, because I can change it at any time. My ex-husband, when he was there, he used the code, but I can never remember the code. I don't like to keep the same code all the time. I change my front door code regularly. I can remember that because I come in and out every day.
Before you came to court here today, ma'am, to testify, did you have an opportunity to watch the trial and watch the other witnesses testify against the court's order?
No.
You did not watch this trial.
You said today?
Before you came here to testify today, had you watched the testimony of the other witnesses in this trial?
I had watched the testimony in the days prior to being told I could not or should not watch.
All week
The
last
trial.
week? So all week last week?
Yes.
What about this week at all?
Earlier this week. Yes.
And did you have an opportunity to report what you were watching and seeing and the updates from the trial to your son?
Yes.
And that's Sean Gathright?
Yes.
And that's the individual you said has a small group of friends?
Yes.
You said he doesn't really get into anything?
Yes.
Doesn't get involved in anything?
Yes.
He previously lived where?
He stayed in California for about a year with his dad.
Did he live anywhere else?
He lived with his dad.
You don't know where that was?
His dad lived in California.
He never lived in Mississippi?
His grandmother lives there.
Okay. And that's the same grandmother that we've...
No, that's not my mom. That's his dad's mom.
So you don't know that if he lived in Mississippi?
I know they vacationed in Mississippi.
Okay.
I don't know for how long. It was when he was staying with his dad.
Your mom is the individual we've heard from, Lorna Allen, is that right?
That is correct.
And you watched her testimony?
No,
Correct?
I didn't.
Oh, you didn't?
No.
So
I
you
was
just...
too anxious.
Okay, so you just picked everyone else's to watch and not hers because you were anxious for her.
Yes, because
You didn't watch it after?
I watched the recap after.
Okay.
But I
And
didn't watch her entire testimony, no.
everyone else, though, you feel like you watched their entire testimony?
Not really, because it can get long. I mean, it's like, one's like 8 hours.
You were relaying back literal names of witnesses, though, to your son, correct?
Yes.
Okay. And you said on direct examination that you do not know Alicia Andrews.
Correct.
Do you admit that you've communicated with Alicia Andrews since her arrest?
Yes, I did.
Several times.
Yes.
And you coordinated for Alicia Andrews to make contact with co-defendant Isaiah Chance on a telephone call.
I don't believe I did, no.
Who is Ariel Chance?
I don't know.
You wouldn't have written a message to Miss Andrews telling her to call Ariel at the time that they've agreed to so she could talk to her boyfriend or co-defendant, Isaiah Chance.
I know I sent her a message telling her that I supported her and I was praying for her because during the hearings, I didn't see, maybe her parents weren't able to make it, and I felt sorry for her. She was facing, life in prison. So I sent her a supportive message. I know I definitely sent that.
Okay.
But
so
as
you know
far as
her.
other specifics, no, I can't recall.
Okay. All right. So you think she's facing a lot of time, and I've seen her parents, but you haven't.
Well, I'm talking about the previous hearings, the court hearings.
Okay. So you're
and
just
the
being
status
supportive.
reports and stuff.
You're just being supportive.
Yeah.
And you testified that your son doesn't have any access to the safe. Nobody in your house has access. Not your daughter, not your son.
Correct.
And you testified that your son is not in a gang, and you don't know anything about his wrongdoings as far as a gang is concerned.
Well, according to the Florida statute, I'm a gang associate.
Why is that?
According to the
Is
statute.
it because you're testifying?
Because according to the statute.
Stop. One at a time.
According to the Florida gang
We don't need you to
statute.
tell us what the statute says. I didn't ask you what the statute says. I
Well,
just want you
you
to
asked
answer the
me why.
questions if you could, please, okay? I just said, did you testify in direct examination that you don't know anything about your son being involved in a gang,
That's correct.
and he doesn't have any access to your firearms because you're in the military and you understand the need that he not have
I'm
access?
retired military, but yes.
If I can just finish the question, just because the court reporter is writing down what we're saying, and she can't write it down if we talk over each other, okay?
Go ahead.
Are you employed now?
I was employed prior to this incident.
Okay, but not at the current,
Not at
this
the
current
current
time? And you testified that he doesn't have access to the safe that you've had for 10
That's
years or
correct.
whatever? Okay, all right. Did you speak to your son about what your testimony would be if you came to court to testify on behalf of Miss Andrews?
No, I don't believe so.
Ma'am, your testimony for certain is that you are the only person, or your ex-husband, both the adults in the house, are the only individuals with access to your guns.
Yes, ma'am.
May I approach the witness, Your Honor?
Yes.
I'm showing you what I'm going to mark as State's Exhibit 115. And would you please take a look at these extractions from your son's cell phone?
safe door pockets. Is it the same thing?
No, ma'am.
821, 520. Okay.
Fingerprints also the same. Your Honor, at this time, the state would actually seek to admit state's amended exhibits, 115, 116, and 117.
Any objection?
Okay.
Okay, admitted.
Ma'am, you would agree that 2023 is within the last 10 years, isn't that correct?
Yes. Would you like to know what safe that's
Ma'am?
referencing?
Listen,
Oh, I'm sorry.
you just need to wait and answer the question that's asked, okay?
Okay.
Ma'am, in 2023, did the device identified as belonging to Sean Gathright send you a message, so from, that indicated, hey, I'm on the way, OTW, to the spot. There was only $120 cash in the safe store pocket, so I grabbed that. Did he send you this message?
I can't recall the specifics, but yes, I guess it would.
115, on August 21st of 2023, did your device from an individual named Mom send your son a message that said, what's the code to the safe? Is that
Yes.
correct?
Yes.
Thank you. And in 2016, or in states 116, 2023, did you send your son a message indicating, hey, Shawnee, at 8:14 p.m.?
Okay.
Did you send the message to your son that says, hey, Shawnee, at 8:14
It
p.m.?
is possible. Yes.
Did you also send, I'm back at home for a few minutes?
Yes.
Does he tell you that he's on his way over?
Yes.
Do you then ask him, what is the code to the safe?
Yes.
Does he respond to you with a code?
Yes.
Do you respond to him, I'm about to leave, I'll get off from you later?
Yes.
And again, never mind, just hold on to it for now, at about 8:43.
Yes.
Does he say, do you want me to put it back in the box, question mark, to you?
Yes.
And do you respond, no, just hold on to it, but be safe?
Yes.
Ma'am, do you know your son to actually have been in possession of any firearm outside of when you have indicated you took him to utilize those firearms
No.
at the firing range?
No.
Do you recognize what was previously admitted as a photograph that was sent to one of the co-defendant's devices or on one of the co-defendant's devices, any of the firearms depicted in this photo?
They're ARs. Okay.
Do you recognize them?
They're ARs.
Do you recognize the specific firearms?
I can't recognize the specific firearms in the picture.
Do you recognize
hate
that
me, you
shoe
two.
as one that your son wears?
I don't know if that's I can't tell you. It's a picture of a
you don't know,
firearm
that's
on the
okay.
floor.
If you don't know, that's okay.
Yeah, I really can't tell you. Oh, snaps.
Are you familiar with what a Glock switch is?
Yes.
Do you possess a federal stamp required by law for which to possess a Glock switch?
No.
Do you have a Glock switch in your possession?
No.
Do you own a Glock switch to use with your guns?
No.
Can you please, for the jury to see, put your hands up so that they can see the front and the backs of your hands, ma'am? Please take a look at the photographs that I am handing to you.
Okay. I don't know who this is. Okay.
Do you recognize any of those photographs?
No, not really.
Do you
Just
recognize?
pictures of, I'm sorry, go ahead.
Do you recognize any of the guns depicted in those photographs?
No, because I don't see anything in reference to them that I would know.
Well, do you recognize any of them as being your guns or similar to your guns?
Similar to mine, yes.
When you went to the gun range the one time, you indicated you brought 2 long guns to shoot?
No, the shotgun and I think one of the ARs and then the handguns.
Did you bring any handguns with a Glock switch?
To the range, no, I don't believe so.
Do you own any handguns with a Glock switch, ma'am?
No.
Please remove that, whatever it is. The purse needs to be removed from the courtroom. I understand, but please just take, no, she
Yeah,
never.
you can take it out.
Okay, yes, thank you. Just remove it, thank you.
I turned that off.
Your Honor, at this time, the state would seek to admit and publish State's Exhibit 118, photograph extraction from the device of co-defendant Sean Gathright.
Okay, any objection?
I do have some objections to some of the photos. I know the other ones.
Would the court like us to approach to address you?
This is a long sidebar. Sheesh.
Ma'am, it's your testimony that you have not seen your son with firearms as well, right?
Correct.
I'm showing you States 118. Do you recognize this firearm?
I can't tell a serial number. It's on the wrong side.
Well, what's on the front of the firearm?
I'm sorry?
What's on the front of the firearm underneath the barrel?
It looks like a scope.
Do you have a firearm or a handgun with a scope that looks like that?
Similar to that, yes. But I can't tell if that's my weapon because I can't see the serial number.
Well, surely you can tell because it has a Glock switch on it, and you've indicated you don't have a Glock switch, right?
Right.
Okay.
I'm
And this
looking
is
at
not your... I'm
The
sorry.
handguard?
This is not your hand, is it?
No.
And this is an extraction from your son's device. Do you understand that?
If that's what you claim, it doesn't
In advance of you testifying here today, did you ask your son whether there was anything incriminating on his phone?
No, I didn't.
Did you ask your son whether he had taken firearms out of your safe?
No.
You
I don't
surely
believe
didn't ask
so.
your... I'm sorry, go ahead.
I don't believe so, no.
You surely didn't ask your son whether he had taken your firearms and used those in a homicide, correct?
Oh, correct.
How about in 118B here, do you recognize this firearm?
That looks like a, yeah, that's a Glock 9mm.
Okay. Do you recognize it as belonging to you, ma'am?
No, I can't read the serial number on it.
Surely you can admit that those are not your legs.
No, and I can't say that that's my gun either.
Okay. And lastly, we'll show you 118C. Did you teach your son how to dismantle an assault rifle?
No,
You did not.
no,
Okay. You don't recognize these pictures from his device?
no, I don't. I don't see any reference, I don't see anything to reference it to. It's just, it's a barrel on a sheet.
Sure, I'm just asking whether you recognize it, ma'am.
No,
That's
I
all.
don't.
Okay. And you lastly have indicated that you do not know your, actually one more. Did you have an opportunity to, at least in your inventory of what was taken or seized by law enforcement, understand that several assault rifles were missing?
No, I never got an inventory from JSO.
Well, you said you replaced the 2 assault rifles.
I knew those were taken. I knew those were taken, definitely, because when I went home after the search was done, they were missing.
Okay.
And I know where they are.
Were they the only 2 weapons that were missing?
Well, I don't know what JSO took.
Which indicates you don't know what you had.
No, they took, I know they took the 2 ARs and they took some of my 9mm. I think 2 of my 9mm, actually.
The exhibit that I previously identified as having been a photograph on co-defendant Rashad Murphy's device. Do you remember me showing you this photograph?
Yes,
Certainly, if your son didn't have access to the firearms, or at least that's what your testimony is, you would not allow his friends to have access to those firearms. Isn't that correct?
that is correct.
Did your son explain to you that he sent a text message to Gutazay or Isaiah Chance on April 27th of 2024, but with that same identical photograph?
No,
No.
no.
Did you know your son or Isaiah Chance to have access to those assault rifles in March or April of 2024?
No.
I'm going to show you what I will identify as State's Exhibit 119. So it would be your testimony that you do not recognize this communication between GZ or Gutazay and your son.
These are not my devices and not my communication, so I can't be asked to identify who they are.
I'm not asking you to identify who they are. I'm asking you if you're aware of the communication. So the answer to that is no.
Well, they're not on my phone, so no, I wouldn't be aware of these communications.
But you are aware that you did not give either permission to access your safe or your firearms, correct?
Correct.
And I'm going to go ahead and publish this photograph of what? Of this message exchange, states 119 state, I mean, the state would seek to admit this exhibit, Your Honor, 119.
Any objection?
No, please.
Submitted. Is it 118 or 119? 118?
119. Prior was 118, yes. I can't hear that, sorry. You've indicated you don't recognize this and did not allow access to these weapons on March 27th of 2023, correct?
Correct. I think that's 2024.
I'm sorry, 2024, thank you, ma'am. So you would not have known anything about this same depiction being messaged between or on Rashad Murphy's device in the 2 days before the homicide. Do you know Rashad Murphy?
No, I don't.
Any reason for Rashad Murphy to have anything from your son's device? Never came around with your son?
No. I thought you said those pictures went to my son.
They did. They did. From
So why would they go
Gathright,
to my-
your son's best friend. Remember him? Do you remember him?
Yes.
Okay.
I'm saying if they're in my home, why would the photo of my weapons in my home be sent to my son who lives at the home?
Yeah, I couldn't explain to you why your son and his best friend were sending photographs of the weapons around that you have, but I'm just asking you why they
And
have
I don't
access
think
to
that-
them.
I'm not saying that those are my weapons. Like I said before, there's no context to it where I can identify where this was taken. You said it's on the phone, that's fine. But there's no context. There's nothing that I can identify as something from my home.
There's no question. The context is you've indicated your son, other than the one time you took him to that firing range, would not have access to all of your
Correct.
assault weapons.
Correct.
Correct?
Correct.
Lastly, you've indicated that your son is not in fact in a gang. Is that right?
That is right.
But you admit that you yourself, you said today, I think, that you are a gang associate according to Florida statute.
Yeah, according to Florida statute,
So you're
because,
familiar.
yeah, I am familiar, I looked it up, because according to Florida statute, if you associate with a known gang member, which is only known to law enforcement, not to any individual person.
Is that extra bit that you've added there, the portion,
No, actually, that's the reality of it.
the statute
So
says?
if you willingly associate with a known gang member,
Correct.
then you are considered a gang
It's
associate.
actually not a question. What's the question?
Well, she said I willingly admitted to being a gang member. I just wanted to clarify that.
That's fine, and Mr. McCormick will be able to clear anything up on redirect, so what's the next question?
You've indicated that you do not have any information about your son being a gang member
Correct.
or a gang associate.
Correct.
I'm going to show you what I've marked as States Exhibits A through F. Please take a look at those photographs.
Okay, what gang sign is this supposedly for?
Okay, well,
Have
just
you had
wait,
an opportunity to review the photographs?
Yes, I have.
okay.
Is it fair to say that your son is depicted in all of the photographs with the exception of one which depicts Isaiah Chance?
Yes.
Is it fair to say that you watched the portion of the trial during which the detectives testified about what a 1200 gang sign would look like?
No, I didn't.
You did not watch the
I
detectives?
did not see that portion, no.
Ma'am, please. You did not watch detectives Drabick or Nieder or Griffin testify?
Not testify about gang signs, no.
You did not see the gang charts that were published in this case?
I saw the gang charts, yes.
Did you see anything on the gang charts that would have been indicative of a gang sign?
I don't believe so.
And it's your testimony that you cannot identify your son as being involved in any gangs, is that right?
That is right.
I'm going to may I please seek to admit, Your Honor, states 114C, A through F.
Any objection? Okay, admitted.
Who is the individual depicted in states 114E, ma'am?
And, I'm sorry, it's 114,
A through F.
114?
114A through F.
A through F, okay, thank you.
I'm not sure.
This is not Isaiah Chance. You're not sure?
Well, I can't see the face, I'm not really sure.
Sure, ma'am. How about 114D?
Oh, that's Sean.
And who else is in the photograph that you know?
I know the other two people in the photograph.
Right, who are they, please?
I'm not going to give you their names.
Okay.
You're refusing to give the names?
Well, I don't think it's appropriate.
Oh, okay, well, you're under oath to tell the truth. so
I
you-
am, and I truly believe it's not appropriate.
Okay, well, I guess you're the
names.
judge now. Okay, go ahead, what's the next question?
They're not involved
Ma'am.
in this.
Ma'am, did you have an opportunity to see all three charts that were presented in court?
I believe I saw one chart.
Do you know which gang it was for?
It was the one that had my son on there as an associate. I
Which one?
remember that one.
Which one?
So I don't remember which name that was, but I remember his picture on there as an associate.
I'm showing you states 114F. Do you recognize the individual depicted in 114F, ma'am?
Yes,
Who is that individual?
that's my son.
How about 114B, ma'am? Is your son depicted also in this one?
Yes,
Which individual is your son in 114B?
he's the one with the hat.
Is he in the center of the photograph?
Yes, on
Is-
the left,
Is your daughter also depicted in the photograph?
perhaps.
Perhaps. May I have one moment, Your Honor?
Yes.
No further questions, Your Honor.
Okay, redirect.
Is there a reason why you don't want other people identified for
Objection, Your
this
Honor,
court?
relevance.
Wait, I'm sorry, what was the question?
Is there a reason why you don't want other people identified for this court?
Yes,
You can answer. Good.
yes, because, number one, the high profile of the case. Number two, I was directly told by law enforcement.
Objection, hearsay.
Sustained as to hearsay.
Okay,
So.
it's a very-
No, ma'am, I sustain the objection. You can't keep answering, all right?
I'm
So
asking-
you're not actually the judge in here. So, and I do appreciate the situation you're in. However, nonetheless, you need to do what I tell you to do. What's the next question?
I'm going to ask you the question, but you don't have to tell me what anyone told you. All right? Are there reasons why you don't want to identify people for the cameras?
yes. I believe that.
Okay, just a yes. Thank you. What's the next question?
Well, I would like for her to explain her answer, Judge.
I'm going to
Well,
object as to.
Yeah, I don't know where this is going exactly. So you can't repeat what anybody said to you. So what's,
I'm just telling you what I believe, and the
okay,
reason why.
go ahead.
So the reason why I believe it would be dangerous for other people to be identified in relation to this case is because of the high-profile nature and the fact that it involves supposed violent gangs in Jacksonville that we have never come in contact with. So I feel like it would be a violation of these individuals' privacy since they're not relevant to the case and they have no relevance to Alicia Andrews
All
as
right,
far
well,
as
now
I
we're getting
know.
into a narrative. So ask the next question.
All right. There's a couple things that you wanted to explain, and all we're asking for is the absolute truth.
Okay.
All right? You were trying to explain something about a safe. The absolute truth. Is there another safe at your home?
There is.
Okay.
My son has it safe in his bedroom.
All right. And you were trying to also mention on cross-examination something about a gang associate and you being a gang associate. Can you explain what your understanding of your title as a gang associate?
Okay, once my son was arrested, I found out he was being labeled a gang associate. In order to be labeled a gang associate, by my interpretation of the Florida statute, if you willingly hang around somebody who is a known gang member, then you could be considered a gang associate. However, nobody tells that person that they're a known gang member, and nobody tells anybody around them that they're a known gang member. So if you're hanging around somebody unknowingly and law enforcement has deemed them to be a gang
Sorry, that just reminds me. If you watched the YSL trial, put a 1 in the chat. But do you guys remember Max Shart asking one of I don't even know what witness it was. It was some officer, I think. And he's like, were they yelling? Or no, it was one of the, indictees, I think, that wasn't part of the 6 that were on trial. He's like, when you were doing this, were you yelling, "This is for YSL," out of the car window? So this idea, well, nobody announces that they're doing this stuff because they're in a gang, just reminds me of Max Shart.
gang member, then you
Oh,
theoretically could also be considered
all the
a
ones.
gang associate.
Alicia Andrews, do you have her phone number saved in your phone?
No, I don't.
All right. And what was the first time that you ever reached out to her?
It was during one of the status hearings. I've attended every single one of my son's status hearings, so there were some where I noted that there was not somebody there for her. So I reached out.
I'm going to sustain the objection.
Had you ever communicated with Alicia Andrews prior to her being
No,
incarcerated?
no.
No further questions.
Okay, thank you. May this witness be excused?
And then they let her go.
Okay, thank you, ma'am. You're free to
All
go.
right, thank you.
All right, who's your next witness?
All right, so we had a little discussion in the chat about, do you want to keep going with Alicia Andrews, which we started rewatching yesterday or last week, or more rewatches from the Julio 4 trial, and then Ksoo was an option. You guys all said Ksoo, so let's hop over. If you guys missed the Ksoo trial, this is part of the back and forth. This gang beef, we're going to hear mentions of Julio Foolio. Oh, here, wait. Quick article. We'll hear the opening statements with more specific theories, but a quick primer. Quick primer. Ksoo murder trial start. This is from before this started. So this is from July 23rd, 2025. Ksoo murder trial starts with opening statements. Attorney says he's not pictured in the shooting video. Ksoo and his co-defendant, ATK Scotty. Trial begins with opening statements with the state detailing gang ties and retaliatory motives. No, why are you breaking? I'm not a robot. I'm not a robot. Well, anyway, maybe we'll just get the, that was too many ads anyway. Anyway, we'll let the opening statements explain themselves. Oh, we can skip that. And then once we get through opening statements, if we're still on verdict watch, we'll jump to what I think were the two spicy witnesses. I know everybody's going to watch the snitching dad's testimony, so that'll probably be the first witness we jump to. Here we go. They're zooming in on his back. Well, let me fix the banner. So that way anybody that comes in late knows what we're watching. This is Ksoo. Is it? Are they gonna unmute us? Right, they swore the jury in. There we go.
The court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Now, before proceeding further, it may be helpful for you to understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity to, if they wish, to make an opening statement. And an opening statement gives the attorney...
All right, we can skip the instructions. But just know that there's two defendants being tried at the same time. Okay, here we go.
May it please the court?
Yes.
Counsel? We are all gathered here today because of a murderous plot that unfolded on January 15th, 2020. A wicked, premeditated murder, a vile scheme that was birthed by a specific group of co-defendants. Individuals who collectively, consciously, and callously worked together to ensure January 15th, 2020 was the day 23-year-old Charles McCormick died. The murder of Charles McCormick was personal. It was thought out. And it was brazenly executed in broad daylight without any fear of accountability. Why? Why did this group of co-defendants think they could exert such violence with impunity? The answer to that question comes down specifically to who was involved. Because this was not just any group of co-defendants. This was not a group of strangers. This was a group of individuals who knew one another, were close to one another, that were family. Every single one of them that participated in this crime were members of ATK, a local rap group. All but one of them were related by blood. This was a crime committed by family. The names of the guilty: Hakeem Robinson, who's sitting right here, whose nickname is Keemy to his family, Ksoo, his rap name, Leroy Whitaker, a co-defendant sitting before him, a cousin, whose nickname is Scotty, Dominique Barner, whose nickname is Butta, their friend, their co-defendant, the only one not related to the others by blood. But he might as well have been, because for years, they have known Barner. For years, they have accepted him. For years, he is one of them. Abdul Robinson Jr., nicknamed Kareem K. Crazy, Hakeem Robinson's biological brother. And his father, Hakeem Robinson's mother and Leroy Whitaker's father are siblings. Abdul Robinson Jr., Hakeem's biological brother, Leroy Whitaker's cousin, and Torrigon Williams, another cousin, also played a role in this crime. After the murder of Charles McCormick was completed by Dominique Barner, Hakeem Robinson, and Leroy Whitaker, and they had to flee what they three had just accomplished, their premeditated murder of Charles McCormick, Abdul Robinson Sr., nicknamed Blue, also got involved. That is Hakeem Robinson's father, and he had to come to the rescue of Hakeem Robinson's cousin, Leroy Whitaker, and their friend and their co-defendant, Dominique Barner, because Dominique Barner and Leroy Whitaker, after fleeing with Hakeem Robinson from the murder, trying to escape the police, crashing their car, Dominique Barner and Leroy Whitaker went one way, Hakeem Robinson went another. And Dominique Barner and Leroy Whitaker found themselves trapped in a house that Dominique Barner and Leroy Whitaker broke into to escape the police that were looking for all three of them, trying to avoid getting caught, avoiding accountability for the murder they just committed in broad daylight. And because Dominique Barner and Leroy Whitaker were trapped, Abdul Robinson Sr. had to come pick them up. He picked them up and drove Dominique Barner and Leroy Whitaker away from that home, away from the police, and it was during that ride that he found out exactly what happened. But he continued to help them and drove them away, and for his actions, he's been charged with accessory after the fact. Throughout history, one common truth has been shared by every person who has drawn breath in this world. There is a day you are born and a day you die. And between those two moments, the life that unfolds, uniquely shaped by one's choices and one's actions. Some of those choices are more profound than others, some actions more impactful. But when a group of individuals, even a family, when they come together and intentionally commit a violent crime, a murder, shattering the laws we all share, there must be accountability. And it is precisely for that very reason that in this courtroom, today, 5 years later, Hakeem Robinson and Leroy Whitaker are sitting before you. And at this moment in the trial, with them, though unseen, are two simple but essential questions. Questions that the state will answer for you with the evidence. And those two questions, which you can write down, where were they? And what did they do on January 15th, 2020? Simple questions. Where were they and what did they do? But those simple questions for Hakeem Robinson and Leroy Whitaker have terrifying answers. Answers that they are desperate to keep hidden from each and every one of you. The truth can be a funny thing. Sometimes, the more out of desperation you try to suppress it, the more the guilty fight and rail against each and every aspect of it, the more obvious it becomes. For example, and I want you to hear these despicable words, let them sink in, because these are the words of Hakeem Robinson. Kill a nigga, then go get my toes done. Kill a nigga, then go get my toes done. Those are his words that he attached to a video
Oh, Lord.
he took of himself as he sat in a chair in a nail salon getting a pedicure. Just a couple days after running Charles McCormick down on foot and executing him.
Twice.
You're going to see that video. You're going to read his words. You're going to see his tired feet. And when you look at that video, you see him, when you see his words telling you what he did, believe him. And let that image, his answer to both of you, all of you, about what he did, sear your collective memories. On January 15th of 2020, these two co-defendants, they shared a motive, they shared a goal, and for their deeds, they will forever share guilt. What was their undoing? What has brought them here before all of you today? Simply, the combination of arrogance, mistakes, and bad luck. For justice's sake, thankfully, the murder of Charles McCormick was captured on video. Thankfully, these two co-defendants in particular left a trail of overwhelming and inescapable evidence in their violent, chaotic wake. Evidence that is much like an avalanche, quickly gaining momentum until that evidence ultimately and unavoidably catches up and buries all doubt in this case. So what kind of evidence are you going to hear? Are you going to see? Evidence in virtually every form imaginable. You're going to see evidence, you're going to hear evidence directly related to the motive in this case, because it was a personal motive, and we'll talk about that in a moment. You're going to see the video of the murder, and that video is a powerful piece of evidence, because not only does it capture the murder, it also captures the vehicle that was used by Dominique Barner, Hakeem Robinson, and Leroy Whitaker when they committed this crime, a stolen Nissan Altima. And you will see that vehicle on video. And there will be no doubt that that vehicle was occupied by the people who committed this crime. And that vehicle was collected, well, evidence inside it was collected immediately after this crime, immediately after they fled from committing the murder from the police. And that car crashed. And inside it, amongst the items that were collected, DNA evidence. DNA evidence for Leroy Whitaker and Hakeem Robinson, fingerprint evidence for Hakeem Robinson, DNA fingerprints forever tethering them to that car, to their crimes. You will also see on that video of the murder exactly what the shooter was wearing. And I want you to pay particular attention to it, because this is a video, not a still photograph. You'll get to see the whole thing. And you will see that the shooter was wearing a two-tone hoodie, gray chest, dark black arms, black hoodie pulled up over his head. And I want you to take note of that, because you will see that same hoodie in photographs and videos wrapped around Hakeem Robinson's guilty body. You will see the distinct firearm that he carried when he committed that murder, when he pulled the trigger. And you will see that same firearm in another video in Hakeem Robinson's hands. Not for entertainment. He used it for murder on January 15, 2020. You also will be presented with call records showing communication amongst these co-defendants and cell site location information, placing Leroy Whitaker, placing Hakeem Robinson where they should not have been, placing them where the guilty. You will see social media posts, in addition to the nail salon video that we've already talked about, another video posted to Hakeem Robinson's Instagram account just a couple days after the murder, a video of Charles McCormick rapping a song. But when you get to Charles McCormick in the video and you see his face, what's added? Hand emojis with the text, bye-bye. And then that's followed up by the nail salon video that we've discussed, where he needed to get his toes done. What I want you to remember, because there is going to be so much evidence in this case against both defendants, and so many different types of evidence, that it's much like a puzzle. While they're powerful on their own, independently, when you put them together, and they come together so easily, so intuitively, when you put these pieces together, you will be presented with the truth of January 15, 2020. And that will be a picture showing each and every one of you who committed this crime. And what will be staring back at you will be the crystal clear pictures of Hakeem Robinson and Leroy Whitaker, just as clear as if you were to turn your gaze over there at this very moment. One of the key pieces of evidence that exists, as I've said, is the video recording of this murder. That video recording exists because Victor Krueger, a citizen, has nothing to do with this, just happened to have a dash cam in his truck, and just happened to be parked at the right place at the right time. That video is completely independent, wholly unbiased, and incapable of lying. It just captured what happened in high definition for each and every one of you to see. And so, when you watch that video, I want you to trust your eyes. Because again, it's not a single photo, it is a video that shows in detail, as Hakeem Robinson, who was the shooter in this case, tracked Charles McCormick down on foot and executed him. Now, that video, essentially it's going to be a time machine, transporting each and every one of you individually and collectively back 5 years. That's how long ago this was. 5 years. Placing you in the position Victor Krueger found himself when he witnessed Charles McCormick's final terror-filled seconds on this earth. But you will get to watch that video from the safety of this courtroom. And I want to be very clear. This is a crime that happened 5 years ago, so when you watch that video, you're going to see the shooter looked like 5 years ago. Not today. Today doesn't matter. It was 5 years ago. Scam. This video is going to be very, very powerful, and I want you to pay attention to it, but I do want to be clear about one thing. Based on the location of the camera, it does not capture the shooter's face. Just didn't. But it's okay, it didn't have to. It captured more than enough detail that that video, along with all of the other evidence in this case, will make it crystal clear that that individual was Hakeem Robinson. I don't expect that there will be any debate that what happened to Charles McCormick on that video is anything other than first-degree murder. I don't believe that'll be a debate. The only question.
Oh, let me pause. Yeah, I don't know. I mean, maybe it says in the chat. I just see that they go to the seal. Let's see if they posted in the. Because they were on the ceiling until like a minute ago. Yep, okay. Kathy does say verdict reached. All right, so here we go. If you've got any final thoughts, you guys, this would be the time. This would be the time. Throw them in the chat. Let's see. Let me put out a notice on Twitter like I said I would. On X. Oh, let me get you guys up here. Sorry. Yeah, that was quick because they were sent at about 11:30, so this is just shy of an hour and a half. Yep, only two options. Only two options here. Life without parole or DP. Put a number 0 through 4 on if you think there's going to be DP recommendations and how many. So 0, 1, 2, 3, or 4 in the chat. Derek says I'm anxious like it's me. And I'm just going to pull up. So you guys are voting quickly. So we've got some 1s, some 2s, some 0s, some 2s, 0s, 0s, 3. We got a 3. Got 4. Back to 0s and 2s. The 0s and 2s are dominating here. Got a 3. Who said 20? Do you mean 2 or do you mean 0 maybe? We've got tons of numbers coming in here. We've got another 4. All right, the judge is there. been an hour and a half-ish. It's like a couple minutes off of an hour and a half. And I am? Okay, we were like 1 second behind, but we're all the way live now. And if you're following the Harvey Weinstein trial, apparently the jury's got a question in that too. They've been deliberating in that trial. Lots of Friday deliberations. Oh, so the numbers in the chat, guys, if you just got here, it's the number of people, the number of defendants you think will be getting a death penalty recommendation. So the options are 0, 1, 2, 3, or 4. Oh, oh, that scared me. The screen just went dark for a second there. What are they doing? Yeah, I wonder if they actually did a lunch, because it's only one. So, I mean, they may have, but I feel like they probably didn't take a lunch. I don't know. Yep, and for anyone that missed it, it is life without parole. There is no getting out early. There is no opportunity to be paroled. It is life. So even if the sentence is life without parole, no death penalty, they'll still die in prison. All right, do you guys think, all right, let's do a question. Now that we've gotten a lot of the 0 through 4 predictions, do you guys think this was quick? Do you guys think this is about right? Do you guys think that they should have come back in like 2 seconds? Quick, slow, about right. Why is the court camera blinking us out like this? Their feed's still going. The camera just keeps going out. Oh, man. Yeah, got a lot of about rights. Quicks. I don't know if I think quick is good or bad because, again, I've never really watched a penalty phase like this to know the difference, but I do think there is something to consider that, again, when you're determining guilt, all 12 jurors have to deliberate and get on the same page. Whereas the recommendation, it's each individual juror decides whether to recommend or not. So they don't have to sit back there and come to terms with one another, even though they might want to have some discussions. They can deliberate, but there's a different ending point, a different way that they can determine deliberations are complete. So, hey, shout out to Fit Lawyer ATL in the chat. And drop some free Mooktunks in the chat. Always good to see you. Hope you're doing well. Yep, it's still a verdict because it's still like the jury has to render this type of decision here for capital punishment for the recommendation. Because again, for like a lesser conviction, sentencing would proceed in front of the judge. It would be in the judge's hands, and the jury would be excused after rendering the verdict in the guilt phase. But with capital punishment, you got to have the jury of peers, decide whether or not to recommend death penalty. So different standards, and part of that is maybe the reason why the state decided, well, let's sever Alicia Andrews from this case. You know, it's a big strategy decision on the state's part to decide whether or not to put on a death penalty case as well, because they've got higher burdens. Obviously, the appeal fight is probably going to be more rigorous when it's a death penalty case. So thank you. Adventure Erin just dropped a link to the Fit Lawyer ATL. Go subscribe to her. Great insight. Actual lawyer, unlike myself, and a really great person. So go check out her channel. I think you'll like it over there if you like it over here. And still no sound in the court. Yes, the verdict is in, guys. The verdict is in. Yes, the judge still does have discretion. The judge will have to, if the death penalty is recommended, she could still decide not to, but she'd have to give an explanation why she's deviating from the jury's recommendation. If the jury does not recommend the death penalty, the judge cannot override the jury's decision and decide anyway to give death penalty. So here we go.
Are you waiting for Mr. Hernandez or no?
Judge, he was not with us downstairs, so I'm not sure where he is.
Okay.
I'm sure he's close. If you don't mind, can I text him for 1 minute, Judge?
The one that is in the middle over there, he's gonna walk back with the evidence.
Which one?
He's in the middle there, Lugo. You know Lugo?
Oh, okay, yeah.
Why?
Okay.
He's not, okay, yours, David.
Thank you for the super and for the update here, Fit Lawyer, on Moontook. Still waiting on the Court of Appeals to issue a ruling on Antonio's Sledge appeal. Thinking they're waiting until after the elections on the 19th, since Paige is running opposed for her seat. Keep the prayers coming, 100%. Moontook, you guys might remember from the YSL trial.
Okay. See.
He's at Starbucks, Judge, which is, I guess, on the corner.
Yeah.
Starbucks?
All right. Okay.
Me when I'm late to work. Oh, it's just at Starbucks.
Judge, the court can go on.
Yeah, okay, let's do that, just because everyone else is here.
Understood, Your Honor.
It's been a long 6 weeks, and I don't want to keep the jury waiting unnecessarily, so, okay.
Oh, hello.
Right?
Yes, ma'am.
Okay. Bring in.
Thank you, Judge.
everyone again, there's not to be any audible reaction after the jury's verdict is read, okay?
I feel like she was looking over at the defense side of the court.
Major?
Yeah.
All rise. All jurors are in this.
Okay, very good. Everyone have a seat. And it's my understanding the jury has reached its verdict for this nothing, that's correct? All right, very good. You would hand the verdict form to Bill.
Yes, ma'am.
Madam Clerk, please publish the verdicts.
Defendant Isaiah Chance, verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Isaiah Chance committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Isaiah Chance was a criminal gang member at the time of the homicide. Yes. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Isaiah Chance should be sentenced to life in prison without the possibility of parole or death. We, the jury, finds Isaiah Chance should be sentenced to life in prison without the possibility of parole.
He's
Dated
staying
this
alive.
15th day of May, 2026, in Hillsborough County, Florida. Miss C.S., foreperson of the jury.
And they said unanimously,
Defendant
right?
Sean Gathright, verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright created a great risk of death to many persons. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright was contemporaneously convicted of a felony involving the use of violence to another person. Yes. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more of the mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Sean Gathright should be sentenced to life in prison without the possibility of parole or death. We, the jury, find Sean Gathright should be sentenced to life in prison without the possibility of parole.
He's alive.
Dated this 15th day of May, 2026, in Hillsborough County, Florida. C.S., foreperson of the jury. Defendant Rashad Murphy, verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy created a great risk of death to many persons? Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy was a criminal gang member at the time of the homicide. Yes. We, the jury, have unanimously found the state proved one or more of the aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Rashad Murphy should be sentenced to life in prison without the possibility of parole or death. We, the jury, find Rashad Murphy should be sentenced to life in prison without the possibility of parole.
Ms. Wise.
Dated this 15th day of May, 2026 in Hillsborough County, Florida. See S for a person of the jury. Defendant Davion Murphy, jury verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy created a great risk of death to many persons. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy was a criminal gang member at the time of the homicide. Yes. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more of the mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Davion Murphy should be sentenced to life in prison without the possibility of parole or death. We, the jury, find Davion Murphy should be sentenced to life in prison without the possibility of parole. Dated this 15th day of May,
They all live.
2026, CS for a person of the jury.
All right, members of the jury, now I'm going to ask you all the same question, similar to what happened after the guilt phase for the full jury. So, I'm going to ask you about the jury's decisions that you have just heard. Juror number 9, initials DM. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 16, initials AM. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 19, initials LY. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 24, initials WW. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 32, initials CRP. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 47, initials AM. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 49, initials CG. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 78, initials AC. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 142, initials TL. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? And Juror 157, initials CS. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? And Juror 158, initials JH. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? And Juror 167, initials JE. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? All right, I have one last formal instruction for you all, then I have something more personal to say. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affairs as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. On a much more personal note, these are tough cases. These are tough cases. And I've handled a lot of tough cases. This is my first rodeo as far as handling tough cases. This one takes the cake. This one was one of the up to date, in my 24 years of doing this as a judge, one of the toughest cases. And you all are amazing. You're amazing people. You are smart, you are attentive, you are patient, and you are just. You're just. And I just want, on behalf of everyone involved, not just the parties, the attorneys, myself, our entire community owes you a debt of gratitude. And I wish I could do something more for you other than just say how amazing you are. I did have the bailiff give you all just a small medallion, it's just a token. I wish there was more that I could do, but that is all I can do. You all should go home, and as you resume your lives, be so proud of yourselves for the citizens you are and the sacrifice that you made for all of us in our legal system. We are eternally grateful. With that, your jury service is now concluded. Thank you.
All rise.
I feel like she was sincere with that. And we could run that back. I didn't expect that from her. I mean, to say that this case was different to her, maybe the age?
Jury's out.
I don't know.
Okay, very good. Okay, so we need to set a date for sentencing and all post-trial motions. All right? So, how much time do you all need to get the motions drafted? We're looking sometime in June?
Yes, Judge, I would ask for a couple of weeks.
Okay. So, I know summer can be a little tricky. How are you guys looking the week of June 22nd? I could do the 22nd anytime, the 23rd in the morning.
Judge, the 22nd would work in the afternoon.
Okay. Mr. Gonzalez?
Fine with 22nd in the afternoon, Judge.
Okay. Ms. Finkelstein?
That works.
Okay. Mr. Sonardi, Ms. Toomey?
Afternoon is fine.
Okay. Mr. Petredis?
I have a trial that week, which is a one day here in Hillsborough, so I can just get it someday that week. Different day.
Sure. And just let me know who the judge is. I'll make a call. Not to worry.
Okay.
Okay, so we're going to set sentencing for June 22nd at 1:30. And
June 22nd.
All post-trial motions need to be filed no later than June 15th. Actually, make that June 12th close of business, and the state is going to follow the clause that thing. Okay? All right, very good. And sentencing, if anybody would like to speak, they can. That would be from the victim's family or friends, same with defendants. I mean, the sentence is mandatory, but cases like this, when it comes to sentencing, I would like to give everyone a chance to say whatever they feel needs to be said, as long as it's respectful. Okay?
Yes, Your Honor.
Okay, very good. See you all then. We are concluded.
All right, so You guys know I'm ideologically opposed to the death penalty, so I'm personally relieved that I don't have to sit up here and not have words, because I don't know how I would have reacted if 4 were sentenced to death. And honestly, I think it would have been a little bit more difficult to sit up here if some were sentenced to death and others weren't, right? And have to, try to wonder or speculate why. So again, I'm not the right person to weigh in on this decision, because I never would have been sat on this jury. They would not have qualified me. And I have a poll up. If you weren't looking at the chat, you might not have seen the poll is up, but if you want to pop over and take a vote quick, we'll leave it up for another minute. But did this surprise you? A little bit of a different question than what would you have done? It's more of a question, are you surprised that the jury came back and just straight across the board said, we recommend life without parole and no death for any of these 4 individuals? When we wrap this poll up, we're going to do a poll on the judge's statements there. We'll watch them walk out. Davion's being walked out right now. Scotty Sonardi has a nice bag here. I like that. Nice. Gathright's being walked out. There goes Isaiah Chance through a different door. And mark your calendars. Sentencing is the 22nd of June. I'll keep my eyes peeled around that first and second week of June for any motions, since their deadline's going to be the 12th. Now what they mean, I saw some questions like motions, ? Not unusual when one phase of a trial ends and before sentencing actually occurs to have attorneys file motions. Maybe they're going to challenge something on a legal basis. Maybe they just need to enter some motions relating to what they want to present at sentencing. And the state will have an opportunity to oppose certain things. But we'll look at those motions if and when any are filed. Think of it like the Alicia Andrews case, where we still have not had sentencing, but we have had her team file several motions. And we're still waiting. Her next hearing date is May 22nd. So let's go back and watch that thinking of the jury. I'm going to end the poll that's in the chat, and then I want you guys to weigh in on, are you surprised that Judge Sisco said this about this specific trial? Do you think it was genuine? Do you think she just says this to all the juries? You tell all the juries that.
And juror 167, initials JE. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? All right, I have one last formal instruction for you all, then I have something more personal to say. Ladies and
All right, so she's saying I have something more personal to say. So, and I wrapped up the other poll, said, did this surprise you? The verdict. We have no at 64, yes at 25, and 11% for only for some defendants. So that's the end of that poll. I'm going to put a new one up about this. And if you think that this case somehow really touched Michelle Sisco in a way.
gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affairs as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. On a much more personal note, these are tough cases. These are tough cases. And I've handled a lot of tough cases. This is my first rodeo as far as handling tough cases. This one takes the cake. This one was one of the up to date, in my 24 years of doing this as a judge, one of the toughest cases. And you all are amazing. You're amazing people. You are smart, you are attentive, you are patient, and you are just. unjust. And I just want, on behalf of everyone involved, not just the parties, the attorneys, myself, our entire community owes you a debt of gratitude. And I wish I could do something more for you other than just say how amazing you are. I did have the bailiff give you all just a small medallion, it's just a token. I wish there was more that I could do, but that is all I can do. You all should go home, and as you resume your lives, be so proud of yourselves for the citizens you are and the sacrifice that you made for all of us in our legal system. We are eternally grateful. With that, your jury service is now complete. Thank you.
All right.
So, I don't know. I personally feel like that was really sincere, and I'm surprised by it. You know, I might not have been like the biggest critic of Judge Michelle Sisco, but I have criticized, there's been some moments where it's like, oh, she's moving it along a little bit more than just keeping the court in order. But I am surprised that she said that, and I wonder if it's truly genuine, which it's my opinion that it was, because I do think she was getting watery, and she gave the jury some medallion. I wonder if she was worried that she would have to get a recommendation in favor of the death penalty and maybe stray from it for one reason or another. Like maybe in her mind, she was prepared to have to diverge from what the jury recommended, how they recommended the death. Maybe she's relieved that she doesn't have to go through all that. So I don't know. I see naturally Miss Tasha saying relieved. Bree says she got teary-eyed. And I know the lighting's horrible, but if I start to get teary-eyed, like my voice does a certain thing, even if I can hold back. And I don't know, it just seemed like that was going on. So, hey, Noitab, there should be a playlist link towards the bottom of this video description with a playlist for the Alicia Andrews trial. And I've thrown in some videos from other creators in there as well that have talked about the Alicia Andrews trial, but you'll find everything from the full trial streams to the recent updates in that Alicia Andrews playlist. So definitely a lot in there to dive into. So glad to have you here. Hope the chat's being nice to you. Glad you're here. Let's see what you guys are thinking. Yeah, Elle, would she stick to what they decided? And remember, she cannot, if they don't recommend death penalty, she couldn't decide at sentencing to sentence them to the death penalty anyway. But if they did recommend death penalty, then she could decide, well, even though you recommended it, I could still give a reason why I'm not going to do that. And she has to explain why she wouldn't do that, but it would have been, she still could have made the opposite choice. Here, she has no choice, and she seems relieved to me to not have to make it. Yeah, Piper thinks she was happy. I don't think everyone hates the judge here, Buckets. Sometimes it's difficult. I know there's character limits, but, I wouldn't really characterize everybody here as hating the judge. Kelly said maybe it's the publicity of the trial. Jetson says this jury sucks. Gotta respect the jury verdict. I think both parties will say they gotta respect the jury verdict here. Let's see. Yeah, Bram, maybe it was due to the age. Let's see. Yeah, chance everybody got, no, nobody got with possibility of parole. They all got life without parole. There's no parole in Florida. And even though we have like an 85% time served, it's not in play for these types of charges. So everybody is going to do life in prison. Unless they have a successful appeal, which if their appeal is successful, they'd probably be on a retrial anyway for any mistakes. And, I wouldn't imagine that a retrial would be any easier for these defendants based on the types of evidence that are available. But still, even with an appeal, they would have an opportunity for a retrial. But outside of an appeal, they're going to die in prison. There is no early release. There is no parole opportunity. That's it. That is it. The only difference today made is that they were not sentenced to be executed at a date determined by the state, by the government. So, Roderick, I agree. Quick verdict, not good. I don't know. Quick verdicts always make me nervous. Long verdicts always make me nervous. So this happened to maybe not be the case if you think that, if you're of the position that life without parole is sparing someone's life, and rather than, some people could view it as doing the rest of your life in prison and laboring is the harsher punishment than being killed and not having to do that, right? But if you think that the less severe punishment is your life being spared, then this was actually a good verdict with a pretty quick turnaround. An hour and a half of deliberations. Again, want to give a shout out to the Fit Lawyer ATL for giving us this update on Antonio Sledge. Again, that's been caught up in appeal. If you guys remember, Antonio Sledge, or Munktunk, is the testifying witness in the YSL trial who the state moved to revoke and successfully revoked his probation. So that's being challenged after his sentence was challenged because it was an illegal sentence. And the Fit Lawyer ATL and Jim Robichaux, the happily angry lawyer, were successful on that. But then all Judge Whittaker did was redo the sentence in a way that there might be some additional issues with. But that's been caught up in the Court of Appeals. So still waiting for an update there. And it's good to just hear that you guys are waiting too. Thank you so much. Crime Junkie says, I figured they would get life without parole, in my opinion. I don't think they deserve the death penalty, but that creep Tanner Horner, separate trial, did. His name is, I know it's been a recent story, but his name has been popping up throughout the chat today. So, and I think with part of that too, the jury didn't get to deliberate on his guilt, right? I didn't tune into that trial, but I was reading like the updates, but he pled guilty, didn't he? So the only decision someone gets to make is the sentence. And maybe that makes a difference too. But then again, the nature, you're abducting a little girl in a FedEx van and killing the girl in the FedEx van. I mean, I guess that's a different circumstance to look at too. So that's a name that's been popping up a lot here where people are like, he deserves DP. Lexi says, thank you for covering this case in the amazing proper manner that you did. We appreciate you, Kat. Well, hold on. Let's give Lexi her flowers. Lexi is the GOAT. Thinking back, whoever in the chat just asked about the Alicia Andrews trial. If you think it'd be too much to go back and catch up on a case, when Lexi's following a case, she does incredible text write-ups, summaries of everything. So if you're ever missing a day and it happens to be a case that Lexi is covering, her written recaps will get you caught up. You won't miss anything that's important. So I know there's interesting things you see when you watch, but if you don't have the time, Lexi is the GOAT. So if you're on X, her link is dropped in the chat here. And I've got to add you to the descriptions. It's Lexi the Law Nerd if you want to look her up. But thank you for the super, and thanks always for hanging out with us and taking the notes. Your note-taking is A+. It's Sheed. Sheed pops in here once in a while. It's always good to see it, Sheed. So they just got here this week for this trial. I'm grateful for the no death penalty part, but I'm ignorant to this case. Right back at ya. Always good to see you all, love. I'm anti-death penalty in general, so I feel the same way. Even though I followed the case, though, I do think the jury took the instructions seriously. They found unanimously that the state did prove aggravating factors beyond a reasonable doubt. Again, 2 of those factors were pretty much baked into the verdict they rendered during the guilt phase. But they still, yes, you did, yes, you did, yes, you did. But for these other reasons, we find that mitigating factors, whatever, outweigh the fact that the state met their burden. So, and again, I'm pleased because I'm not a fan of the death penalty. A big reason for that, you guys, I cover a lot of wrongful convictions. So I usually don't cover trials where, when I saw the videos of the Tesla and the hotel shooting, and people are like, are you going to cover the Julio Foolio trial? I was like, they've got him dead to rights. So unless something funny comes up, right? Sometimes cases seem obvious, like the Brendan Banfield trial that recently happened in Fairfax, Virginia. But there was some weird stuff going on with the police department, internal disagreement between the investigators. So I wouldn't have been interested in a trial where it seems like the defendant, they've got him dead to rights, the evidence is crazy, but then something went so fundamentally wrong with the integrity of the case, it came on my radar. But you guys asked for this one. And I've never watched a death penalty case before. So we did it, even though 2 years ago I was like, what are we going to watch? Like, it's on video. And over time, we learned that there's even worse stuff. We have this Airbnb 8-minute search while we're trying to figure out what Airbnb Julio Foolio might be at. Like, what are you guys doing? What are you guys doing? But it really has turned out to be an enlightening experience to watch this type of full penalty phase play out. I see Darissa here saying about the judge, she may feel like they were young, impressionable, and truly made a mistake. Maybe Isaiah and Sean, I don't know. I kind of had a fear before I knew that the state was seeking 4 aggravating factors against Davion and Rashad. There's only 3 aggravating factors for Sean, and there's only 2 for Isaiah Chance. I was nervous that what if we got a split death penalty decision and it was the Murphys? Would that be explained away by age only? Or would there be something else at play? And I sat there marinating on it and I was like, I hope that we don't split that way. And maybe having the numeric difference between the aggravating factors could explain it. But before I knew that they had 4 versus 3 versus 2, I was like, man, what if there's like implicit reasons, implicit bias drives the determining factors why jurors decide to split the baby on a death penalty decision? How do you deal with that? And you never really know. You wouldn't really know the reasons for that type of recommendation. But I was like, what if? What if? Especially being able to see some of the commentary in the chat. So, again, just glad there's no death penalty. What? Adventure Aaron? Mistrial declared in the Weinstein trial. The Harvey Weinstein trial. Jury deadlocked. Verdict Friday, guys. Verdict Friday. I've been following that case through Lauren Conlon, who's been at the courthouse. Thank you, Aaron, for sharing that update. Let's see. Oh, and she has some juror insights? Sweet. So I'm going to keep an eye out to see if we get any jurors that speak for this case, of course. And I know this is a different case than what we're here for today, but I do like to see when a juror talks. I think it's always interesting. So Lauren Conlon here, and I'll share a link to her. She does great coverage of a ton of cases, especially the David case. If you guys are interested in that, she is on it. She said, I just caught up with 2 alternate jurors for the Harvey Weinstein trial that just got declared a mistrial while waiting for the lawyers outside. They did not want to be on camera, but both stated they did not think the Manhattan DA proved Harvey Weinstein's guilt beyond a reasonable doubt. And she's speaking, she says they're alternate jurors who were not inside the deliberation room, but did not think the prosecution proved their case. So, yeah, it's a bit of a different sentiment than just, I think he's innocent of these charges. It's, hey, I'm taking the burden of proof seriously. So, interesting juror feedback there, as always. Let me get her link. Thank you, Aaron, for that, because we just mentioned, I guess we thought there was going to be a jury question. It must have been a note that they couldn't. They were at an impasse. So here is Lauren's link in the chat. Again, she covers a ton of cases and does really great interviews with attorneys from different cases as well. So, and then I think we've had you guys voting. Let's close up our poll here. That will be the bow on this stream, you guys. That'll be how we wrap it up. This final note here. Let's see. You guys said, are you surprised Judge Sisco said, I left it at this because there's a character limit, but all of that. And we have a 60% yes, I'm surprised, and it's genuine. No, and it's genuine was the next top answer. So I'm not surprised or I am surprised. Either way, I think it's genuine. And then for the not genuines but surprised, 13%. And not surprised, but it's not genuine. Like she says this to everyone. She tells all the juries this. I got a 9%. So I thought that was nice. And I really think stuff like this must be tough for jurors. I mean, imagine you were in the middle of a case like this thinking about all this back and forth. Should you sentence someone to death? There's all this killing. Should you sentence someone to death? And then you've got to go to your daughter's graduation and pay attention. Like, some people have a hard time getting in the moment. Some people can get in the moment and then like later it randomly pops into their mind this other thing that they were pushing out. So I think jurors, they do a great service. If you guys get called for jury duty, I know there's the joke of trying to get out of jury duty, but I hope watching trials, if you thought jury duty is something everyone tries to get out of, I hope you want to serve. I hope you want to serve on the jury. Yes, let's go over all the polls. I got them locked and loaded here. Let me paste this one before I lose this one. Let me save these numbers real quick. Let me open a document so I can like make the text really big and show it on screen. Because I don't know about you guys, but I have a hard time following numbers when they're just read out loud. So let me put them all together. I've got some old polls for Alicia Andrews too in here in my notes for this trial. Because I kept the notes together. Okay. I might be missing some days, but we'll see. And this is kind of going in reverse chronological order. I guess it's still kind of small for you guys. All right, so we predicted jury deliberations. Remember, they only deliberated for an hour and a half for the penalty phase. The chat predicted they would deliberate less, 50%, so you guys were right. About the same, which would have been the 8 or so hours for the guilty phase, at 29%. And then we had 21% thinking longer, so the 50% was right. We did a poll next on Sean Gathright's closings. Do you think they persuaded the jury? And 46%, most of the chat said yes, they were persuasive and more towards saving life. We had 26% say they moved towards the death penalty. For Isaiah Chance's closing, this is all penalty phase. Do you think it was more persuasive? And this looks like the same, almost the same exact breakdown. It's like 1% off. More towards life, 45%. Uh-oh. Davion Murphy's closing. You guys got a little bit of a variation here. On this one, instead of the 46 and 45 persuading the jury towards a life, it's only 40% for Davion's closing, and we had 33% say it was more pushing you towards the death penalty for Davion. And really the question is, do you think it persuaded the jury, not you yourself? And then Rashad went back up closer in line with Isaiah Chance and Sean Gathright, that his argument by Daniel Hernandez would persuade the jury more towards life at 44%, but still a significant amount, 32% think their argument pushed more towards death penalty. And then we did a how would you vote, which, you know, we don't always do the how would you vote. We usually do predictions. We had 2 options for death penalty for none. And I actually think this is one of the most interesting poll results. So we did 2 options, death penalty for none, just because you're morally opposed to it. It's not your beliefs. No matter what case it is, you are just across the board opposed to the death penalty. 32% of our chat was in that bucket, right? So that's kind of like out of the running. You guys wouldn't be able to be part of this jury. Like me, I wouldn't be able to be part of it. But for the other 3 choices, we have death penalty for all 4 was at 30%. death penalty for 1 through 1, 2, or 3. Anything less than 4, but not a full life without parole, was 21%. So 51% of this chat would have opted, if they were on this jury, to give the death penalty for at least one defendant. And it's limited because there's only 4 poll choices, so we had to lump something together. And then 17% who did not choose the option that they're ideologically opposed to the death penalty said they would still choose death penalty here for nobody because of the factors of the penalty phase. So I think that was an interesting, enlightening to see. There's a lot of us in this morally opposed bucket that just can't participate. And then we did our predictions. So let's see. A lot of people got these wrong because a lot of the prediction was that yes, the death penalty will be recommended. So these polls, will the jury recommend death penalty for Sean Gathright? There was a no choice, and then there were 2 options for yes. The yes was either unanimously 12 out of 12 will recommend the death penalty, and the other yes was they'll reach the 8 threshold. So it could be 8, 9, 10, or 11 jurors. So for Sean Gathright, 48% of the chat predicted the jury is not going to recommend death. 52% of the chat believed he's going to be recommended death. And we know the jury's actual verdict here, but that was the prediction last night when we closed the stream. For Isaiah Chance, the chat said no, the jury will not recommend death. 49%, about half the chat was correct in their prediction. And again, about 51% said yes, they will recommend, and that was not the case. For Davion, we had slightly more people predicting that the jury would recommend death penalty for Davion Murphy at, instead of like the 51-52, here we're at 55%. 45% of the chat said no. And then for Rashad, I think it's kind of interesting. Not really, he had a kind of swing, I would say. If you compare it to Rashad and Davion, and maybe it's the nature of us voting right after the closing arguments were delivered, but we have 51% voting the jury would not recommend the death penalty for Rashad. So even though it's by a hair, that's the highest vote for no recommendation for Rashad out of all 4. And then for unanimous, he had a really low percentage. You know, it seems like even those who were predicting that the jury might recommend for Rashad, that they didn't think it would be unanimous. So, and again, I always appreciate you guys taking part in these polls. I know they're not a perfect science, but it's great food for thought. And then these polls go back into the conviction phase. So we are past that. We are past that here. You know, we knew that last week. We went over those polls. But there we go. So I do try to save these polls so we can look back at them. Again, I do forget to paste them when they end in the chat. Sometimes I forget to put them in my notes, and then actually I don't know if they can if I can go back in the chat and see the history, but kind of don't. Let's see. Nope, everybody. Oh, I should have changed my banner. I'm sorry, guys. Life without parole was the recommendation across the board. We'll make it say verdict is life for all for the final minutes here of this stream. Any closing thoughts, you guys? Any closing thoughts? Are you asking me? Cookie, are you asking me why do I support them? Sometimes I think people are lost or like they don't listen, but I want to, is this question for me or am I missing something in the chat? The judge can't overrule. The judge cannot give death penalty without a recommendation from the jury. Again, something we have discussed that several times, and I know several people are posting the reminders in the chat. And it's not an opinion. It's by law in Florida. If the jury does not give the recommendation, whether you agree with that law or not, or wish the judge could or would just go rogue, It's just not available by statute. So, Adventure Aaron says, I'm glad. To me, some of the language used in the presentation of mitigation seemed like it was for the judge's consideration and not the jury's. I'm glad it didn't get there. And interesting, I didn't think about that either, but some of the things that could feel sort of awkward, like, you know, if a defense attorney's saying this and they're trying to fight for their client to get life, couldn't the jury take this the opposite way? But at the same time, it's a good point here that they could have been making those points for the ultimate decision by the judge, right? Because if the jury did recommend death penalty, it gives the permission to the judge to have that option. And she's supposed to follow it. And if she doesn't, she's supposed to give reasoning, but she can deviate. But that option is just not on the table at all if they don't give that recommendation. So interesting point. Interesting point. We've got, and the statutes, by the way, I do try to specify when we're talking about Florida. I don't know if it's the same in every state that a judge can't determine death penalty without a juror recommendation. I actually don't know how it works in different states. I feel like a lot of states have that principle where the jury has to give the recommendation, but I'm not sure if I can say that every state has that. Every state that has the death penalty has that same requirement. So let's see. There we go. I was waiting. Adventure Aaron says in Missouri, judges can sentence to death without a jury recommendation. Yep, so there's a variance between the different states. So, you know, I try to be careful not to speak generally, try to make sure I'm speaking about Florida when we're talking about Florida, because different states have their nuances. So, all right, you guys. Is there, let's see, I see some more questions. Will they all go to the same prison? I mean, I'm sure they could, but there's a lot of different factors that can go into play with where somebody will go. And even if they go to one place at first, there could be reasons why they would be transported. We might hear some indicators, you know, maybe before sentencing, some pre-sentencing stuff that, you know, hey, they're having issues at this facility. So I just don't know. I don't have that information. But do they have to go to the same facility? No. There's a good chance that just because of geolocation, like they're all being tried and arrested here, they might be at the same facility for a short while and there could be a transfer after. But there's a lot. And again, a lot of attorneys could advocate for their client to be housed in a specific prison facility. So we've got, that's true too, a bench trial. You know, if you do a bench trial, leaves it all up to the judge. Another good nuance there. Another good nuance there. Ooh. And I don't know. It's like, there are some things where it's like, I'd rather have a jury. And there are some things where I'm like, I'd rather have a judge. We recently watched another, I don't follow Florida cases just because I'm in Florida. It just so happens that there's a lot of crazy cases that happen down here. But we recently watched it was Cole Goldberg. And it was like the Boca Boat Bash. It's like a big event that goes on in Boca. And he was accused of like attempted murder on a girl that he was dating at the time after they were both trying to swim in the water. And the state's theory was that while he was in the water, he grabbed onto her trying to strangle and drown her in the water. And the defense was like, no, he thought he was drowning and just grabbed on the body that was in front of him. And that was a bench trial. That was no jury. And I think that was a very good case, a good example of a case that maybe I'd rather my hands be in front of a judge. So that was a short trial, an interesting one to watch if you guys want something to watch over the weekend. So, and then we've got, yes, no DP, just life, all four. They went all or none. So they chose no death penalty recommendations. So, and then we've got, let's wrap it up there, you guys. Do you guys want to be redirected to more like legal stuff? Who do we want to raid? Or raid somebody. Say hey to somebody out there. Who's live? Whose live is it anyway? I see recovery addicts covering, it says manslaughter jury trial, but that's all I can see from these titles. Austin Drummond hearing. I see verdict watch in Josie Dykeman. I don't know if these are, I don't think those are court cases. And then we still have, I see a few streams that are still doing Julio Foolio. So, yep, verdict, life without parole for all four. You guys want to do Austin Drummond? An interesting case. Austin Drummond case, interesting. So, we're getting some recovery addict votes. All right. Put DD for defense diaries, RA for recovery addict, and the first to get 5 non-repeat votes is who we're going to raid. So always good. I think it's always good to raid somebody, show some love. It's a lot of fun to raid another chat. I don't think I can raid Judge McBurney. I don't think he has the feature turned on factual. Can you imagine me going to a court stream on YouTube, Judge McBurney, and we're like, cat raid, the cat gang is here. I don't think he has the feature turned on. Oh, goodness. My goodness. Also, God's Devil Dog saying, prior to 2016, judges could override a life recommendation for death. The U.S. Supreme Court struck down this practice in Hearst v. Florida because it allowed judges to make crucial findings rather than juries, violating the 6th Amendment. Yep, so no overriding. No overriding. So, good to know. That's actually really good to know. All right, sorry, let me count. All right, so the first initials I saw, we have 1 for defense diaries, 1 for recovery, 3 for recovery addict total. All right, so we're recovery addicts winning. Recovery addicts doing a manslaughter trial. Look, I don't know who it is. It doesn't say a name in the title that I can see. And defense diaries is doing Austin Drummond. So put some initials where you want to go. All right, 2 for DD. FFS, be careful. You better get that checked out. Car accelerating on its own. You better get that checked out. Thank you for being a member for 21 months, but geez, don't die. All right, you guys aren't voting, so recovery addict wins on this one. But shout out to Defense Diaries. I'll drop their link. And say hey to recovery addict and tell him how nice his microphone is. His sound is awesome. All right, guys, that is set up for a raid. We're going to raid recovery addict. Defense Diaries link is in the chat, so say hey to whoever you go and crash. Thank you so much. We've got a few cases that every case I want to talk about just keeps getting delayed. But some upcoming hearings, right? Everything is a hearing. Like all of these trials are getting kicked back. We had an Antonio Brown hearing today. The accuser was a no-show on Wednesday, but they showed up today. We have Rashawn Jones. That case ended in a mistrial a few weeks ago, and there's a motions and bond hearing on Monday that if there's a feed, we can get together and watch that. Also on Monday is in the Fat Joe case, a civil case, the extortion, defamation, all of that mess. Fat Joe versus Terrence Dixon and attorney Tyrone Blackburn. There's a sanctions hearing. I don't know if it'll be streamed, but try to get some coverage in there that we can report on. That whole case has been one of the biggest messes I've ever seen. The 22nd of May is the Alicia Andrews hearing. The 26th of May is the Phoenix Eichner hearing. That is the FSU shooter who used ChatGPT to like ask questions right before the shooting, how to undo the safety on a shotgun, and was looking up all types of stuff on ChatGPT about, you know, what parts of the campus are going to be the most crowded and at what time. So that's the criminal trial, but there's also civil suits that have launched against ChatGPT. So a lot going on over there. Courtney Clenny, the case that never seems to get a trial date. She's got her next hearing on June 1st. June 5th is the Brendan Banfield sentencing. June 11th, if you guys remember hearing about he's now drafted, but he wasn't drafted at the time. Now NFL player, Zachariah Branch, arrested right before draft for like obstructing a sidewalk in Athens, Clark, Georgia. Well, they're still pursuing that because he has an arraignment date scheduled for June 11th. And I thought, based on the complaint, I thought the report was internally inconsistent because the officer noted that she asked him to move and then he moved, but then apparently in her opinion it wasn't enough and she just decided to cite him anyway. But that case is still proceeding. She's actually prepared more since. So that officer is maintaining that he was obstructing, and I can't obtain the body cam because it's part of an ongoing investigation. But that's scheduled for the 11th, so I'll be looking for an update on that. And then the 23rd, even if you don't want to pay attention to Antonio Brown hearings, if you like trials, this is a Florida case, there's going to be a stand your ground hearing, which is going to be a mini trial to put up an immunity from prosecution defense. So Antonio Brown's team is going to argue, look, this complaining witness, this alleged victim, attacked me and my actions were in self-defense, so I should be immune from prosecution under Florida's stand your ground rules. So it's going to be a mini trial. It's going to be half a day, and they're starting it in the afternoon. So I think that'll be interesting if you want to mark your calendars for that. And sentencing, I didn't add it to the graphic yet, but the 22nd for this trial. So those are all of the upcoming things that are on my radar. Of course, new things come across my plate every day. So hope to see you guys soon for something else. If you're not interested in any other topics, hope to see you for the sentencing hearing for this trial. And I want to thank you again, like profoundly, for coming in here and sharing your thoughts. And, you know, sometimes these chats are a little bit different than normal, but everyone that's new, thank you for tuning in. Everybody that's been here before, thank you for being so welcoming to everybody that got here for the first time for this trial. And thank you for being a really insightful chat. I really, really appreciate it, especially on a case that I was nervous about covering. So you guys all have a great weekend. See you somewhere in these YouTube streets, and please take care.